Okay, you want to get started? Do we have everybody on the committee here? I can see Chris, Mike, Euless.
I don't see Megan. Just, I don't think she
Okay,
indicated.
well, get started, and if she joins us, that's great. Um, Good afternoon and welcome. My name is Edward Carney, and I am the co-chair, along with Sherry Levin Wallach, of the Advisory Committee, tasked with identifying options on whether and to what extent the New York State Court of Appeals should adopt pre or post admissions requirements supplementing the next gen bar exam. The purpose of this hearing is to receive views from interested individuals, organizations, and law firms on possible options. I'm going to go around. First, I'd like to, I should introduce myself again. My name is Edward Carney. I'm a retired 4th Department Appellate Division judge, as well as in the 2nd Department. I'm pleased to be here today. I'm here today with my co-chair, Sherry Levin Wallach. If you'd like to introduce yourself, and then we'll go around and have the other members do their introductions. Sherry?
Thank you. Thanks, Judge Carney. Hi, everyone. I'm Sherry Levin Wallach. Nice to see you all, and thanks for joining us. Looking forward to hearing all of your testimony today and the furtherance of these discussions. So thank you for joining.
Okay, Judge Glenn?
Hi, and again, welcome to everyone. I'm Chris Glenn. I'm a retired surrogate and also a retired dean of CUNY Law School, where I got involved in bar stuff in the mid-90s and have sort of never given it up.
Yeah, thank you. Do we have Megan Chamberlain with us yet?
Hi. Yes, I'm here. Hi,
Hi,
everyone.
great.
It's nice to see you. I'm Megan Chamberlain. I'm the firm-wide director of legal recruiting at Kirkland & Ellis, and looking forward to hearing from all of you today.
Okay, Dean Euless Boyd.
Good afternoon. My name is Euless Boyd. I'm the Dean of Admissions and Financial Aid at Brooklyn Law School. I've served here for 10 years, and I'm also looking forward to hearing from you today.
Thank you. And Michael McNamara.
Hi, good afternoon. My name is Michael McNamara. I'm a senior partner at Seward and Kissel in New York. My primary area of practice has been litigation. Like Chris, I've been involved in the bar world. I was the president of the New York County Lawyers Association. I've been active at State Bar until about 9 days ago. I was on its executive committee. I'm still the chair of the finance committee. And I was on the task force at State Bar that looked into the UBE a couple of years ago. And I look forward to hearing from all of you.
Thank you, Michael. Okay, I think we're going to hear first from the Honorable Michael G. Hayes, Dutchess County Surrogate, and the Honorable Asa Mosey, the Erie County Surrogate. Is that correct?
Yes.
May
Okay.
I, Judge, just say by way of disclosure that I am a member of this association as a retired surrogate, and that I brought to the attention of the association this process, what this committee was doing, and the possibility of testifying. I have not been involved in the preparation of their testimony or whatever written documents they've submitted.
Thank you. Judge Hayes, how are you today?
Very good, sir. How are you?
I'm fine. You can proceed whenever you're ready. We're delighted to have you here and looking forward to hearing your comments. Thank you.
Thank you. Thank you for that. Thank you for the opportunity to appear and to provide testimony today. And I saw Judge Mosey is on the Zoom call as well. And so I'm going to kind of lead us off, and then Judge Mosey will be our closer. So,
Sounds good.
And I would do
Judge Hayes, if I may interrupt, I just joined myself. My name is Vincent Versace. I don't think I was listed to appear and speak as well, but I was going to introduce Judge Hayes and Judge Mosey, if I may.
Oh, that would be great. We know that we've received some written comments from you, Judge. Welcome. And why don't we turn it over to you to introduce the two judges?
Thank you so much. I wanted to start off by thanking the advisory committee for this opportunity, not only to submit written comments, but to expound on some of our concerns and our thoughts here verbally and here on the record. We think it is very a very, very important topic, and one that, quite frankly, not only impacts all the courts across the state of New York, but has a tremendous impact upon all the surrogates court across our state. So we thought it was very, very important that we offer our testimony here today. Judge Hayes was kind enough to introduce himself and Judge Mosey, but I will do it once again because I think it is appropriate. Judge Hayes is the surrogate of Dutchess County. He has the privilege of serving there for the last 5 years, I believe. And Judge Mosey is the Erie County surrogate as well. And she also serves as the treasurer of the New York State Surrogates Association. Again, my name is Vincent Versace. I'm the current president of the Surrogates Association. I have the privilege of serving as the Schenectady County surrogate. I just wanted to say before I turn this over to Judge Hayes, is that we think it is incredibly important that this committee, as it has, thoughtfully consider whether there should be any changes made to the state-specific licensing requirements. Specifically, we think that the advisory committee should think carefully about whether or not trust and estates should be a meaningful part of the licensing requirements, and that consideration be made that, in fact, trust and estates should be part of these licensing requirements specifically. Because as we outlined in our written submissions, and I don't want to be repetitive, but it has been our anecdotal experience as well as those of other judges across the state, particularly in surrogates court. We believe that the most recent crop of graduates since the changes have been made since on or about 2015 have adversely impacted the preparation for attorneys practicing in the surrogates across our state. But at this point, without further ado, without getting too much in the weeds, Judge Hayes was kind enough to quarterback and lead up the subcommittee that looked into this very important issue and helped me craft and submit our written document to you all, which I, of course, invite you to review if you have not already. Judge Hayes, if you'd be so kind as to follow up these comments.
I will. And I'm going to lay claim to 7 years as the surrogate.
Oh, I'm sorry.
Give me credit for 5, but I want my full 7.
I was never known as a mathematician.
Yeah. So in the views of our membership, which is comprised of the surrogate court judges from across New York State, the answer to the question of whether the bar exam should include New York specific requirements is straightforward. The stated purpose of the bar exam is to assess and to ensure an applicant's competency to practice law in New York. Not simply competency to practice law in general, but to practice law here in New York. And it stands to reason then that the bar exam must include New York specific requirements. The bigger and thornier question from our perspective is the form and extent of those requirements. Our testimony today, like the written statement that Surrogate Versace filed on our behalf, is based primarily on the observations and the common experiences of our members. But we recognize that relying solely on personal observations lacks rigor, and it can easily be dismissed as overly anecdotal and subjective. So in our written comments, we've taken the time to identify several empirical studies and published reports that provide some insight into a worrisome trend that our members have been observing now for a number of years, and that is a marked decline in the level of the preparedness of newly admitted attorneys who seek to practice law in New York, particularly in the area of trusts and estates. Death touches us all. It is, as Dr. King so eloquently put it, the irreducible common denominator of man. And reflecting its universal nature, attorneys throughout New York are frequently called upon for advice in trust estates matters, whether by clients, family, or friends. It's therefore no coincidence that the trust estate section of the New York State Bar Association is by far the largest of its 28 sections. The T&E section has nearly 5,000 members. That's more than 700 than the second largest section and more than 1,200 than the third largest section. And given the pervasive reach of trust and estates law, it is critically important that candidates seeking admission to the bar have meaningful exposure to the fundamentals of New York's unique trust and estates law prior to admission. But it has been the observation of our members that those newly admitted attorneys frequently lack a grounding in those fundamentals. This has been a source of surprise and concern for many of us. I can tell you frankly, it never occurred to me, and I believe that this is true of many of my colleagues. It never occurred to me that there was a connection between the decline that we were all observing and the adoption of the Uniform Bar Examination in 2015. And I think one of the many laudable benefits of this public hearing and the process that you're now engaged in and in seeking the input of stakeholders as to what the next version of the New York Bar Exam should look like. One of the many benefits of that is that it caused us as an association to take a hard look at the issue. And what we have learned as to the state of affairs in the 10 years since the UBE was adopted was, to many of us, shocking. 10 years later, there's now no question that there's been a substantial shift away from New York law in the curriculum of New York law schools. New York practice is not being taught or is being taught to a small niche of motivated students. Likewise, coverage of substantive distinctions in New York law has largely gone by the wayside. And that shift is not limited to law school curriculum. New York Bar Review providers also no longer cover either New York practice or significant substantive distinctions in New York law. This was documented during the testimony of several New York Law School deans and professors during a series of public hearings conducted in the fall of 2019 by the New York State Bar Association Task Force on the New York Bar Exam. And during a published interview earlier this year, Justice Mark Dillon, a justice of the Appellate Division, Second Department, a 16-year New York practice adjunct faculty member at Fordham Law School, and a Dutchess County resident, I would note, reported that student interest in New York practice crashed following adoption of the UBE, and crashed are his words, not ours. Judge Dillon went from teaching one of Fordham's 4 thriving New York practice course offerings to a standing room only crowd every year, to now teaching Fordham's only remaining New York practice course. And even that course is now comprised of a small group of third-year law students and international LLM students. Equally troubling, perhaps more so from our perspective as surrogates, Justice Dillon reported that bar review providers are now actively discouraging students from taking New York practice, trust and estates, or family law. The impact of these curricular trends has been observed by our members beyond surrogates court. As you may know, many of the surrogates in rural counties are what we call multi-hatters. They're elected to surrogates court and county court. Some are elected to surrogates, county, and family court. Other surrogates, such as Surrogate Versace and I, are elected as full-time surrogates, but we also carry substantial caseloads as acting justices of the Supreme Court. Our members and their judicial colleagues who sit in those other courts are all witnessing a decline in newly admitted attorneys' familiarity with New York practice and New York substantive law, and the importance of establishing bar exam standards that sufficiently motivate applicants to study these fundamentals is amplified in the rural areas that encompass 44 of New York State's 62 counties. According to a study conducted by the Albany Law School Government Law Center in 2019, nearly half of these attorneys are solo practitioners, and most of the other attorneys work in small firms of between 2 and 5 lawyers. The majority of these lawyers describe themselves as generalists and identify real property law, family law, and trust and estates law as the 3 busiest portions of their practice. And more than half of these practitioners are at retirement age or are soon approaching it. And I will tell you that even though Dutchess County is not considered to be one of those 44 rural counties based on its population, I'm seeing all of these same trends here on a daily basis. A newly admitted attorney pursuing the general practice of law at a small rural firm or in solo practice lacks access to the mentoring, training, and oversight that larger firms can provide. The same is true of newly admitted attorneys seeking to practice law in historically underserved communities of the more populated areas of New York, where small firms and solo practitioners are also prevalent. Thus, we believe it is critically important that the New York Bar Exam is designed to provide applicants with a sufficient incentive to study and understand the fundamentals of core New York law practice areas including, of course, New York practice and trust and estates, and that be accomplished prior to their admission to the bar. Again, we're trying to assess the competency of people to practice law in New York, and the starting ground has to come prior to that admission. We are concerned that the current version of the New York bar exam already, as it exists today, does not incentivize candidates for the bar to develop a baseline familiarity with trust and estates law. And as of July of 2026, trust and estates will be dropped from the list of potential topics on the multi-state essay examination. And then when the next gen exam is implemented in 2028, trust and estates will be excluded entirely from the foundational concepts and principles portion of the exam. It will be tested, if it is tested at all, because it's discretionary, even as to the foundational lawyering skills exam. But if it's tested at all, that's where it'll be tested. And as the National Conference of Bar Examiners has expressly stated, applicants are, quote, are not expected or required to develop a base of knowledge in the areas of law that will be tested in the foundational lawyering skills exam, and will instead be provided with the necessary legal resources to demonstrate the skills being tested. What that means is that without a meaningful change to the New York law portion of the New York bar exam as it currently exists, an applicant will not be required to have any familiarity with trust and estates law prior to seeking admission to the New York bar, which means that law students who plan to sit for the New York bar exam will have no greater incentive to take a trust and estates class than students currently have to take a New York practice class. To the extent that it might be tested or on a portion of the test that they'll be completing, the materials will provide the answers essentially on its face, and it's a matter of testing their skills to find those answers within the provided materials, but it requires no background knowledge of the fundamentals to get there. And that is, unless the Court of Appeals takes action by reforming the New York portion of the bar exam. Our association firmly believes that it's absolutely essential that the New York bar exam afford trust and estates law proper treatment in a manner that incentivizes candidates to make more than cursory efforts to acquaint themselves with the fundamentals of New York trust and estates law. We also firmly believe that if the Court of Appeals takes that approach, that will have a direct impact on the curriculum of New York law schools and on the content and emphasis of New York bar exam preparation materials. And that summarizes our overall position, having had the pleasure of spending those few minutes and certainly being willing to have a conversation with any follow-up questions you may have. At this point, I'll turn it over to Judge Mosey.
Thank you. And first and foremost, thank you very much for giving us this opportunity. I echo all of the comments that were made by Judge Versace, all of the comments made by Judge Hayes. I want to set us apart. And it's important that everyone on this call recognizes why the trust and estate section of the bar and why our section that we are presiding judges over and are honored to do that for our constituents, but why it is so important. I have the honor of addressing the UB law students every year. They come to our court, they learn about all the different courts. And I start by saying to each of them that no matter what, and it used to be taxes and death, but I think it's just death now. You can count on the fact that every practitioner is going to have to deal with one of their clients' families, asking them about the trust and estate section and why that is the reason that we are by far the largest section of the New York State Bar, why we have so many practitioners that are involved in the section that find it to be important. And it's because they need to be prepared to service their clients. And by not having this on, and by not giving them the background and the tools that they need, they won't have the ability to service their clients in a basic need when they are in need the most, when they're going through the loss of a loved one, when they turn to you as their attorney and they ask those questions. And as Judge Hayes was saying, we are seeing that they are not prepared. And there is a direct correlation since 2015. And with that, they're not servicing their clients in the manner that we have promised to give them. And we are not, therefore, as the judges, having attorneys that are prepared to do that on behalf of the families they represent. And I find that to be a saddened situation that we never thought that we would see ourselves in. And I implore you to set us apart from all of the other sections, recognizing that this section and this area of the law affects every single one of us, every one of the practitioners you're putting out there in the world, and every one of their clients. And with that, I thank you for your time, and we appreciate that we had this opportunity.
Thank you, Judge Mosey. We appreciate it. Any questions from the committee? Sherry?
Sorry, I was trying to get myself off mute. The story of Zoom. Thank you, judges. It's great to see you all. Haven't seen several of you in quite some time, but thank you for joining us and providing the testimony. My questions are, I'd like to hear your thoughts on what type of testing you feel would be appropriate to fill this gap or, rectify this issue. And what I mean by that is, there's been discussion about should we have an open book? Should we have a closed book? Should we have multiple choice? Should we have more essays? These books, should we have a course that's required in addition to the exam? These types of things. And so there's also been discussion of courses that require people to take tests along the way, right? So that they actually take the course and we know they've taken the course. So there's a number of these options that have been thrown around and discussed, and I'd love to hear your thoughts on how you think it would be best and most effective for us to test the students. And I recognize that what you're saying here, is that, and at least I think what I'm hearing and what I've heard before is, if we test it, then they will be required to study it, right? If we don't test it, then they're just not learning it at all. And so I appreciate that. And so I guess we're trying to figure out, in what form you might suggest.
Right. And, we're trying to stay in our lane to a certain degree as well. We understand that we're not, what's the phrase I read in the material, psychometricians, whatever, the people who know how to put together pedagogy, I can't even say the word, but a sound, informed, evolved way of teaching and learning. We're not against that. We're not here as a group, shaking our fist about, we want to go back to the old ways. What we want is something that is producing newly admitted attorneys who are more prepared to serve their clients and to get the job done that needs to be done, both on the estate planning side, long before we get to court. And if it's done properly, oftentimes we never really get here. And to be able to handle an administration. And yeah, I think at some level it is field of dreams. If you build it, they will come. If you test it, they will learn it. And what's the way that New York part of the bar exam currently works, from our perspective, doesn't create any incentive for anybody to learn it. Certainly as to trust in estates and New York practice and undoubtedly in other areas, but we're the surrogates, so that's where our focus is. And so, I think if we start from, yes, this is important, there needs to be New York specific components, and what we're currently doing is not producing newly admitted attorneys who truly are competent and ready to practice law in New York, then it's okay, now build a better mousetrap. And there are people who probably have more skills, who definitely have more skills than any of us would, which is why in our recommendations, we gave some very general recommendations about, well, incentivize the law schools to build this into their curriculum more, incentivize the bar exam provider companies to do the same. But then we came up with a third option, which we haven't really discussed yet, which is create an opt-out mechanism where a student could, by taking and successfully completing a New York practice class and one other class that included substantive distinctions in New York law from a list of fields or areas of the law that ultimately the Court of Appeals would select, New York practice plus one other. And if you successfully complete both of those, then you can opt out of the New York bar exam altogether. And because really we recognize that, you know, the NYLC, it's a 17-hour video. I don't know how many topics it tries to cover in 17 hours, but it can't spend any meaningful amount of time on any of them because of the volume that would be involved. And no matter what version of that you pivot to, without going back to the old ways, it's still going to have its deficits, and nothing could replace the benefits of a New York practice 3-credit class in law school and one other 3-credit class that serve these objectives. And if we create, if that opportunity was created, so anybody who doesn't take advantage of that opportunity still takes a New York bar exam, but there's that incentive in our mind, the benefits of spending a semester learning a field of law in 2 distinct fields would outweigh whatever the benefits are of an NYLC type mechanism.
Thank you. I don't know who's it, Chris or Mike?
Both of us, probably.
I don't know who's first.
I defer to Mike.
Okay.
Okay.
Thank you, Judge Glenn. Well, to some extent, thank you all for your testimony, and thank you for the written submission. It's very much appreciated. To some extent, Sherry has anticipated my question, but let me, and I understand that you want to stay in your own lane, and I appreciate that. None of us are psychometricians, so I certainly appreciate that. I'm interested in your views about the opt-out on the course. So you mentioned New York practice plus one other, and I wonder if you think that trust in estates needs to be taught somewhere, and whether that needs to be mandated in some way. And I wanted to ask you, you mentioned Justice Dillon's interview that was published in the Bar Journal, and in that he basically suggests that the current exam really isn't working. He thinks it's not sort of difficult enough, challenging enough. He talks about mistakes he's seeing more routinely in his court. He suggested the possibility that the exam could be made more challenging, and that might encourage people, either some combination of encouraging people by virtue of that to take more New York practice classes or actually mandating it. I wonder if you have any views on that.
I'll jump in at first, but I don't want to be the sole voice here. You know, there's 3 of us, but we're in 3 different locations, so it gets you know, a little challenging, the Zoom world. I'll just say, from my perspective, I don't know that I can't say I speak for the association here because we haven't taken a position as a group on it. From my perspective, the open book model is not working, and I know there's a desire to get away from rote memorization, and whatever my skills are, rote memorization is not one of them. So, you know, I certainly understand that, but I think what we currently have isn't working, and whether it's a more beefed up New York law class type curriculum, more than the 17 hours with more meat on it, combined with, you know, not having access to all the materials in front of you. I've read all the same things I'm sure you've read about, you know, the New York's part of the bar exam has become an exercise in indexing. And if you're good at indexing, you're going to get through it no problem. I don't know whether that's true or not, but I just know that that the core sentiment that Judge Dillon expressed, which is that the current version of the test isn't hard enough, isn't challenging enough, and is therefore not incentivizing students to come to the bar exam with a core level of competency and topics that the bar exam providers are telling them not to worry about. That I think I can speak for the association and say that's our observation as well.
Thank you.
Again, you know, I don't want to beat this phrase to death, but I'm certainly not an educator, and I like to stay in my lane. But the bottom line is, I mean, and we're way over our time, but if I may, my one comment is that at the end of the day, I think it's just human nature and common sense that people are going to study what they need to study in order to get through. These, you know, these young men and women are very busy, and they are going to try to focus in on what they believe is most probable to be on the exam. So I think the specter of, number one, trust in the states being on the exam, coupled with some sort of course hours requirement that trust in the states be taken as kind of a condition precedent to taking the exam, maybe something that this committee wants to take a look at. But at the end of the day, we believe that New York practice / trust in the states needs to be taught and a requirement before a individual is allowed to practice law in the state of New York, with whether it be a New York practice, be part of a New York practice overall component or standing on its own. We believe it's necessary and appropriate for all the reasons that Judge Mosey indicated, that this is probably, for most young lawyers that are being admitted in this state, is going to be some level of the service they provide to the folks that come seek their services. So we think it's very, very important that a robust portion of the requirements prior to being allowed to be admitted to practice law be required before being admitted.
Thank you. Judge Glenn?
So, I don't know whether other people got an opportunity to read this stuff, but I spent the weekend reading everybody's submissions. And I was very interested in the submission of the city bar, which spoke to a really, I don't want to say beefed up, but a really thoughtfully prepared course to replace the current course that is given as part of the New York aspect of the bar exam. On the theory that you learn more in a class where you have active learning and interactive activity with the professor, and you have exercises to do and so forth, than studying either black letter law or whatever. And I would just say, from my own personal experience as becoming a surrogate with very little circuit court experience, that I was blown away by how totally different and confusing and bizarre the practice, the rules of practice in the circuit court are from the rules in all the other courts. So even learning some black letter law about trusts and estates and so forth is very different from understanding the SCPA and why we have decrees and not judgments and so forth. So I'm asking, I guess, whether you think that, whether you think optimally, which obviously isn't going to happen, everybody should take a course in surrogates, in trusts and estates, and in New York practice. And that's not going to happen. It's certainly not going to happen for the foreign students. But whether, if we continue with a law course, with or without an exam that follows it, that course should really focus on New York practice and these three other areas of law, one of which is trust and estates, that so many lawyers who end up practicing in New York actually end up practicing, even if they're not practicing it because their neighbor, their family, their friend, their dentist, whoever asks them. And also with regard to the procedural aspects of it, that it just makes life easier for you and your clerks if people know what they're doing when they walk into the court than if they don't. So I guess the question is, do you really want to incentivize as much serious learning about the practice as possible? And could that be done, as the city bar proposes, just in a really good, validated, carefully thought out, 20-week course that everybody who applies for admission to the New York bar has to take, so that everybody knows basic stuff about New York practice, about trust and estates, about family law, and then I forget what the other one is, but whatever it is. And whether that would suffice, and or whether you would still be interested in an opt-out for people to take the courses, one of which would include trust and estates. And then I guess all the membership of this huge section could encourage, young lawyers to take that course as opposed to maybe something else.
Right.
That's,
I think, go ahead. Hey, go ahead,
well,
Judge Mosey.
I think that's such an excellent question. And I read what the city bar was saying, and it was very thoughtful. And I think that that's a great starting point. If that was a requirement, the 20 hours, you clearly are learning more in a classroom environment with people being presented with real life situations oftentimes, and getting them prepared. and getting them ready for the questions that they're going to be asked by the individuals coming to them asking for their services. And it is obviously a very important section of the law, but if there was a course like that for a lot of officers that used to teach trust in a state, that have less people or no people, or the class isn't being offered any longer, or they might be getting 17 people instead of 100 people. And it's, people, as Judge Versace was saying earlier, people are only going to take the classes that they need to take in order to pass the bar because that's their goal. But I think that they would recognize that they're not getting the background that they need when they start getting their first, second, third, fourth client. And it'll be that quickly when they start getting those questions answered. We are a specialized court, and that is clear. The surrogates court is specialized. We have our own set of everything, from computer facilities to the statutes that we're using were referred to separately in the Constitution in the state of New York. We clearly are a specialized court, and we're a specialized court for a reason. And I think it's imperative and important. Most of the students that come in don't even understand that basic fact. They don't understand that every single one of our petitions are a special proceeding and start with jurisdiction all over again. Those are the basics of basic and could be easily taught within a class. As Judge Glenn was saying, maybe that 20-hour credit class that might cover all three and the New York State practice. And I do think that the city bar came up with very thoughtful suggestions on that.
Thank you, Judge. Okay. Well, we appreciate testimony today. We appreciate the judges that appeared today, as well as the Surrogates Association, putting some information out there for us. Thanks so much. And you have a
Thank you.
Thank you for the time.
Thank you. Take good
Thank you.
care.
Okay. Okay, our next individual is Mary Lou Bilick, co-chair of the New York City Bar Association's Council on the Profession.
Thank you. I appreciate having the opportunity to speak here on behalf of the council. And the council speaks on behalf of the Association of the Bar of the City of New York. I'll say personally, I got involved in thinking about the bar exam when I took it. I remember that summer when my father said to me, "You're going to spend 3 months memorizing the law of nowhere?" And I said, "Yeah, that's pretty much it, Dad." But later I started to think of it more deeply. And I was on the city bar's, what was then the Committee on Legal Education, and the reporter on the first report they did on the bar exam. And remembered thinking there's got to be a better way than this. And I applaud New York's, the NCBE and New York's Court of Appeals for creating the next gen, and then for the court deciding to use the next gen. My remarks, I have a couple of points. 1, don't add an exam. 2, do consider creating an interactive, robust online course, or consider enriching the existing CLE program. Think of a way so that the timing doesn't add burdens to the law school graduates who are already in debt and in need of income. Think about the topics based on the topics that people are most likely to go into solo practice in areas where they wouldn't have the support of other lawyers, and think of alternative pathways. So the big points are, don't add an exam. And why not? Because you've already got a valid, reliable exam that's going to sort the many applicants to the New York bar into 2 groups. One group who haven't demonstrated minimum competence, and one group who have. And I would let the 7 years of research that went into creating the next gen exam and deciding what topics should be tested and how those questions should be developed. And in testing those topics, I would rest on their psychometricians and the development of that exam to sort between those who are competent and those who are not ready yet to practice in New York. There certainly is another level that New York lawyers have to achieve in order to practice competently. And that is to competently find and use New York procedural and substantive law. On that topic, I would remind you that only half of New York takers go to New York law schools. So when you're talking about should we add a course requirement to law schools, you're really only thinking about what's happening in the law schools across the state, unless you're suggesting that other states are going to add courses in New York practice and study the important laws of trust and estate in New York for those people who are going to practice in that area. Secondly, I would say we've developed an urban myth that people used to take New York practice in droves. I was the associate dean of a law school for 10 years, and fewer than half of our students took New York practice most of the time, and that was more than at most law schools. So it wasn't that that we've gone from 100% to nothing. It may well be the case that fewer students are taking it now that they can learn it in the NYLE, which is another way to think about it. Don't add another exam. Do consider creating an interactive, robust online course. I mean, you might want to think about beefing up the current New York law exam, but I'd like to think about it as something totally different. There are platforms that you can use to gamify it, to give people incentives and medals to work their way through levels of actually picking up, finding along the way. I mean, you can almost visualize if you've looked over anybody's shoulder when they were gaming. I don't want to suggest that anybody in this group is a gamer, but if you know anything about games, you can almost visualize. I'm not suggesting we do it this way, but the background of these platforms is set up so that people are incentivized to find the law, what they need to get to the next level of their journey, and then to move on in the settings that simulate the representation of actual clients. What we know is that when people rely on their memory, they lose almost half of what they've learned in less than a year. So I don't think we can rely on a test to know that somebody, by the time they get admitted, that half year's over. I mean, so I don't think we can rely on that to know that they'll know New York law. But if they've used it to build a case in the representation of an actual or simulated person, they are likely to remember it today and tomorrow and for the rest of their lives. You could add a multiple choice course if you want to test at the end of that course. If you wanted to, I think it's challenging to create one that's going to be, you'll have to create one that's going to be reliable in a way that it will resist attack, unless it's one that students can take over and over and over again. It's the sorting exam where you run into the trouble with proving that it's both valid and reliable. With respect, so you could, if you don't want to do that, you could beef up the in-person CLE, or the CLE that new lawyers have to do. That's a huge opportunity to actually ask new lawyers to draft complaints and draft answers and draft contracts and be part of a negotiation, all sorts of things that would actually get them to find and use New York law and to be prepared to represent clients in matters involving, their children's custody, or at a hard time in their life when somebody has died, or whether they can continue to live in the apartment, which is the only place that their family has to live. But the current, there's, a requirement of a CLE program. I think it's a place that where we as a profession might want to invest in ensuring that we are providing quality, interactive education that involves experiential components that give adults an opportunity to try to learn how to represent people competently using New York law. I would suggest through all this that you try to think hard about ways to time whatever it is you recommend, so that it doesn't build on top of the time that students have already spent in law school, and to think hard about which are the topics where new lawyers are going to be practicing on their own, and least able to get the kind of supervision they need. I also encourage you to think not of fully formed lawyers who are 10 years out when you think about what it is new lawyers need to be able to do. New lawyers need to understand the foundations and frameworks of every area that they might practice in. And they need to know how to do legal research, and they need to know the laws of professional responsibility. They need to know the general outlines of the courses, so they can think through they can think through remedies, and they can think through how to help their client achieve what their client needs. But they don't need to know the exception to the rule. They need to know to look for it. Finally, I would encourage you, as other courts have done, to consider alternative pathways for some of the graduates. New York is never going to be able, I suggest, to allow to only admit lawyers whose work in practice has been evaluated and judged competent. I do think that, like other states, New York has the capacity to do that for a select number of graduates, and that doing so would incentivize people to do the kinds of jobs that create more access to justice, and where we are most desperately in need of lawyers. And that's where I'd like to leave it. I'm happy to take questions. I think my written remarks are fuller, but I trust that you have looked at those and don't want to bore you with repeating them. So I'm happy to field any questions that you might have.
Yeah, thank you. Are there any questions for any of the members of the committee? Well, we appreciate your time here today, and, oh, I'm sorry, Michael.
Whoa, 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 we're letting the witness off way too easy.
Yes.
Thank you. Thank you for your testimony, and thank you for your submission. And thank you for taking a creative approach to this. I have a couple of questions for you. In terms of the online course that you're proposing, could you talk a little bit about who do you foresee actually developing that test? Do you see that being sort of the bar providers like the Kaplans of the world, or would we need psychometricians to sort of tell us what we should be testing and whether what we've got sort of makes sense? How long would the course be? Are we talking, I guess the current course is 15, 17 hours, something like that. Sort of what would you foresee? Maybe just put some flesh on the bones of sort of how you would see that. And I guess the second question is, we've heard repeatedly, you just heard, I think you were probably on, you just heard from the Surrogates Association. We've heard repeatedly from judges, practitioners, bar associations, that the newer lawyers admitted since 2015, 2016, they just don't know enough about New York law and about New York practice, and that's become a significant problem. And do you share that concern, and do you think that this will actually deal with that, address that problem?
Okay. On how would the test be created? I think it would probably be created by a Kaplan or a Barbary, in conjunction with, there are a number of labs around the country at law schools that are already gamifying law school courses and creating other kinds of online interactive platforms. I mean, just simple Callie, the computer assistant lawyer, it's CALI. Uh, I don't remember what the legal instruction, computer assistant legal instruction. They're kind of experts at this. And they do a lot of things with branching, so they're not quite as graphic and visual and fun. There's no shoot 'em ups or, visuals like that, but they do branching in a pretty sophisticated way where you start to make decisions about what your next move would be for your client and where you would file, where you have venue, where you have jurisdiction, and then it takes you down paths. And if you hit a dead end, you have to go back, realizing that the first part was wrong. Something like that. I mean, that is the way this generation spends a lot of their time. But it also reflects that when this goes to the second half of your question, I think, when you see a lawyer in court, when a judge sees a lawyer in court, not knowing the answer to a question, is it because they didn't know the question was in the field? Is it because they don't remember it? Is it because they're not prepared? I mean, I think what a person needs to do, give you all a lot of credit. What you need to do as a lawyer, the integration of knowledge and your understanding of professional responsibility and the context of the situation and using your interpersonal skills and then knowing particular laws, having totally internalized your client's needs. That's what a professional does, not just know a certain law. And when a person can't, looks like they're operating incompetently in court, it's that they haven't put that package together. It's not necessarily that they don't know a particular piece of law. I don't know that there's been a decline since 2015. I mean, honestly, there's a disconnect between law schools and practice, and there's a disconnect between the old bar exam and practice. So where the fault lies exactly, I don't know, and I don't know of a actual study that shows that people know less law now than they did in 2015, or less New York law. There may well be one. The idea of an online course of the type I'm suggesting isn't 30th century thinking. It exists in courses in law schools. There are 2 law schools in particular that have kind of technology labs that have developed some of these courses. Callie has developed some of these courses. And then there's some other sources in one of the articles in the footnote in my presentation. I don't know exactly how long it would be. I don't know. There is no way to test in every area, as you well know, because you're going to be made to choose among them, right? There's no way you can test in every area that a lawyer might practice in. What you need to test is whether they know enough to find the law and they know how to find it. So I would suggest that a key component of a test like this would be knowing what the main sources are in New York for the various New York laws, right? And how to find those. And there are ways to test legal research. The next Gen exam is going to test legal research, but they're not going to test New York specific legal research. And I think building out a module that exposes students to how to find the New York specific law and how to do that is an important piece of it.
Thank you. Dean, someone else have their hand up for a question? Oh, okay, well, we thank you for being here today.
Sure. Thank you.
Okay, next we'll hear from David Marshall, co-chair of the New York State Bar Association Committee on Legal Education and Admission to the Bar. Mr. Marshall? Okay. Professor Susan Darrow Kleinhaus, Touro University. I know you were present earlier.
I'm here.
Okay.
I'm present, and
Good
I'm
afternoon. How are you?
I'm a little nervous. I've never been invited before to speak before a committee. So I did write to you, and I'm glad that I did. And thank you very much for then asking me to speak with you. And I hope to answer any questions that my rather lengthy statement to the committee presented, but I'm happy to begin by summarizing the three main points that I covered, that I'm sure from what I've read and what I've listened to, I haven't heard others bring before the committee. So, or bring to others who are concerned about our next New York bar exam. So
Well,
if that's okay with everyone.
sounds great and welcome, and you can proceed.
Okay, thank
Hey,
you.
Ed, can I interject for just a second? I see David's back.
David's here. Let David
Is
goes
it your
first.
plan to let I don't know that it matters, but is your plan to let David testify?
No,
after
David goes
Suzanne?
first.
Okay, we can hear from David. I'm sorry, Professor, just bear with us. I'm sure he's got things scheduled too. We're getting a little bit behind schedule already. So David, are you with us now?
I am. I thought I was before. Perhaps I was on mute. Can you hear me now?
Yes. Well,
Okay.
glad to have you. Welcome, and we'll let you proceed. Sorry about that. It looks like we're having some technical difficulties today, but we can see and hear you loud and clear.
Excellent. Thank you. Thank you for inviting me to testify today. To provide context for my testimony, let me briefly describe my relevant experience. I practiced labor and employment law in New York City for almost 40 years. I participated in the hiring, training, and supervision of scores of associates during that time. Since the 1980s, when I started to practice here in New York City, I've witnessed the practice of labor and employment law evolve from a concentration on federal law issues litigated in federal courts and agencies to a practice conducted equally, if not more often, in state courts and agencies under state and local law. For the past decade, I've also taught doctrinal and skills courses as an adjunct professor at St. John's University School of Law. And at St. John's, I serve as the faculty advisor to the Student Labor and Employment Law Society. Based on the extensive career counseling that I do with current students and graduates, I've come to understand the challenges they face today in completing law school, finding jobs, preparing for the bar exam, and actually finding success and satisfaction on the job. Currently, I'm co-chair along with Suzanne Darrow Kleinhaus of the Committee on Legal Education and Admission to the Bar, the New York State Bar Association. I've been on that committee since 2015 and also served on several task forces that have reported to the association on the bar admission process. I'm actually especially proud of the work that the association task forces did to remove barriers to law school enrollment and bar admission that arose from bar application questions concerning applicants' treatment for mental health conditions and their criminal justice involvement. What I particularly liked about the association's approach was that it showed its commitment to improving access to the legal profession in a way that was nuanced and evidence-based, and that balanced the interest of increasing fairness and access to the profession with the interest in maintaining standards for protecting the public. So it's in that same spirit that I'd like to share with the committee certain material facts about the bar exam and admission process that I've learned over that 10 years and that I believe are critical to a sound evaluation of the options available for reforming the current New York law exam and law course. And I'm going to borrow an approach that many of you are familiar with from Federal Rule 56.1 and New York Uniform Rule 202.8, where I'm going to list the material facts that I think are not genuinely in dispute as a way of kind of joining the issue and clarifying the matter for the purposes of the advisory committee's deliberations. So I'll just list them in numbered order. The first fact as to which there is no real genuine dispute is that the test of New York law that's administered by the Board of Law Examiners prior to the adoption of the New York Law Exam in 2016 was evaluated by a panel of independent psychometricians. And those psychometricians determined that that exam was valid, reliable, and non-discriminatory. In contrast, the current New York Law Exam has never been evaluated by independent psychometricians, and it's never been determined by them to be valid, reliable, or non-discriminatory. Material fact number 2, the New York Law Exam is regarded by many applicants as a test of familiarity with where the answers can be found in the Board of Law Examiners outline, not a test of applicants' knowledge of and ability to apply basic principles of New York law. And the New York Law Course video program has been described by those applicants as outdated, out of alignment with the questions on the New York Law Exam, and really a time-consuming chore that they run in the background while they're doing other tasks. And together, they view the New York Law Exam and the New York Law Course as a gatekeeping device, some call it a hazing device, that operates principally to burden or even exclude non-traditional applicants who are seeking admission to the bar, rather than a genuine assessment of their competence to practice in New York. Statement number 3, since the adoption of the New York Law Exam in 2016, student enrollment in courses of New York practice has declined dramatically. So has the number of courses providing instruction in New York law as a core component. I heard Dean Bialik say that's an urban myth. That may be a myth in Syracuse or in Ithaca, where those schools have large numbers of students who don't practice in New York after graduation. That is not an urban myth here in metropolitan New York. In the cited source, you'll see that the reference to the places, the law schools, where the decline has been dramatic. If there's any doubt about that, then what this committee can advise the court to do is to collect that data. That data is in control of the law schools, and they would be able to provide it to you as to how many students enroll now compared to that period of time, how many times they offer the course every year. Statement number 4, since adoption of the New York Law Exam, New York Law Course protocol, judges and practitioners have publicly lamented the decline in newly licensed graduates' knowledge and ability to practice New York law. Number 5, the large majority of New York law graduates who obtain employment immediately after graduation practice in the state of New York, and they enjoy little or no benefit from score portability. It was score portability that actually prompted New York to discard that psychometrically validated exam that we used prior to 2016 and adopt the UBE and substitute the New York Law Course. But score portability, in hindsight, has turned out to benefit very few graduates of New York law schools. Statement number 6, the next gen exams decrease in testing time on day 2 of the bar exam from 6 hours to 3 hours on day 2 is going to allow New York to administer a New York law-specific exam on day 2 for 3 or 3.5 hours. And New York will be able to use the very same facilities, the same equipment, the same personnel, and the same disability accommodations that were used for that administration of the next gen exam. By doing that, New York can avoid imposing on bar applicants and on the Board of Law Examiners staff the additional costs, administrative tasks, personal burdens, emotional stress, and time investments, all of which are often cited as a reason not to have a New York-specific bar exam, that are associated with the current New York law regime, which, by the way, does have those costs because that exam is administered on dates separate from the next gen's twice yearly exam dates, which requires all of those people to do it again at least 3 times a year, in addition to taking the next gen exam, or now the UBE. 7, New York's Next Gen's focus on skills testing is going to give New York the opportunity to focus its New York specific test on assessing legal knowledge, legal reasoning ability, and legal writing skills in an exclusively New York context. That goal can easily be achieved by repurposing and updating the professionally validated essay and multiple choice questions from more than 2 decades of a New York specific bar exam that are currently sitting in the Board of Law Examiners archives. Statement 8, using those updated essay and multiple choice questions in the BOLE files from that pre-2016 period will not force New York bar applicants to shift from learning how to analyze and apply New York law to memorizing minutia regarding judges' filing requirements or statutory time limits, as some have alleged. Why? Because psychometricians in 1992, under contract from the Court of Appeals, evaluated the 1992 version of the New York bar exam, and they concluded that it effectively tested 14 of the New York law domains that the New York Court of Appeals specifically designated as necessary to practice competently in this state. And those psychometricians concluded that the exam did not emphasize memorization over legal reasoning skills. In addition, if you use those updated essay questions from the Board of Law Examiners files, we'll correct for an imbalance that's going to be created by the Next Gen exam. That imbalance is this, and I think it's critical to understand this. There is no essay question on the Next Gen exam, which requires any kind of long form writing of a reasoned legal analysis or factual analysis. What they've done is jettison that type of exam, the multi-state essay exam, in favor of integrated question sets. And all those require are short written answers of a sentence or two. Statement number 9, law schools teach to the test. That's evidenced by the repeated insistence from the law school deans that they require years of advance notice of any changes to the format or content of the bar exam so that they can adjust their curriculum. If you use a shortened version of that pre-2016 New York bar exam, we will restore the incentives to teach New York law and study New York law that made mastery of basic New York law principles and procedures a standard feature of New York lawyers' education prior to 2016. Statement number 10, 12 to 14,000 applicants sit for the New York bar exam each year. They graduate from more than 160 different law schools. 30 to 45% of them in any year are educated outside the United States. The sheer volume and variety of applicants that New York must assess for competence makes a written exam, which can be given and graded in accordance with uniform standards, the most practicable means of achieving at scale validity, reliability, and fairness in the assessment of applicants' basic competence. Let me talk about 3 of those non-exam alternatives that I've heard discussed in these public hearings. The first is a Daniel Webster Scholar type program. That's not a model for New York because it doesn't scale to New York. The Daniel Webster Scholars Program annually accepts about 24, sometimes fewer, rising 2L students who have already been vetted by the Board of Law Examiners and the professors at New York's only law school. They have 1, we have 15, so that they will get into a carefully prescribed 2-year program. And when I say carefully prescribed, they don't have a lot of choice. They take 2 years worth of doctrinal and skills courses that have been specified in collaboration between the Board of Law Examiners in New Hampshire and the faculty at the Sol Franklin Pierce Law School in New Hampshire. That program can't be scaled to New York's applicant pool. It can't be scaled to the size of our New York Board of Law Examiner staff. It can't be scaled to the widely varied curricula and cohorts of students at New York's 15 different law schools. In fact, I would say that small states' experience with alternative programs does not provide a reasonable basis for New York to implement an alternative to testing that grants bar admission based on diploma privilege or a receipt of a certain grade in a certain course in law school. The Oregon Supervised Practice Portfolio Pathway is another alternative that's been discussed. That program's only a year old. It also doesn't provide a model for replacing the New York law exam with an apprenticeship program that'll scale to New York's size of the applicant pool. It's only been in effect for about a year. Let me give you the numbers. 47 students as of last year had enrolled. 62 attorneys had applied to be certified as supervisors. It's also still too early under that program to evaluate whether that program's design is going to solve problems that have been experienced in other contexts where they use an apprenticing model to license lawyers, specifically in Canada and to a lesser extent in England. What are those problems? The people who apprentice find themselves to be the victims of sexual harassment by their supervisors, discrimination, financial exploitation, and inequitable access to apprenticeship opportunities, so that they wait much, much longer to get an apprenticeship and get licensed as a result of the limited opportunity to apprentice. We have no idea whether those problems have been solved in Oregon, and certainly no realistic opportunity to do that here. Finally, with respect to CLE courses, New York's required CLE courses for newly admitted lawyers of 32 credits in some very specific subject matter and skills areas for, I think, at least a decade. During the time that requirement's been in effect, the concern about new lawyers' readiness to practice in New York hasn't abated. And there's no evidence that burdening newly admitted lawyers with the cost and money and time of completing additional CLE courses would correct the problems associated with the current testing protocol in New York. There's also no evidence that any system of scoring a new lawyer's performance based on CLE courses could ever equal the validity, reliability, and fairness of the New York bar exam that was validated in 1992. Statement 11, the time's now upon New York to draft a New York-specific exam of 3 or 3.5 hours. Give sufficient notice to law students and law schools about the subject domains to be tested and the exam modalities to be used. Spending time now designing pilot programs of non-exam alternatives that are only going to be available to a few dozen or a few hundred applicants will distract from that important drafting effort. And it's not going to do anything to satisfy the demand for a valid, reliable, fair exam of New York law that can be administered in July 2028 across 12 to 14,000 applicants. And finally, and this is extremely important, the New York Court of Appeals, when it acts in its capacity as an agency responsible for how lawyers are licensed to practice in New York State, is the only body that has as its principal duty and objective the protection of the public from lawyers who lack basic competency in New York law. Moderating growth in the cost of legal education, increasing representation of the profession from people from non-traditional backgrounds, reducing stress, they are all worthy objectives, but they are the primary purpose of other institutional actors, not the New York Court of Appeals in its licensing capacity. In part because those other institutional actors have available to them a far broader array of tools to address those problems than the licensing agency does. None of those laudable goals, by the way, are going to be achieved or advanced in a meaningful way by eliminating the requirement of a rigorous New York specific exam. Who will suffer if that's done is the public that the New York Court of Appeals as a licensing agency is responsible to protect. And with that, I'll take your questions.
Sherry?
Hi, David. Good
Hi,
to see
Sherry.
you.
Nice
Thanks
to see
so
you too.
much for hearing and for your testimony. I just would like your thoughts on when you referenced the 1992 version of the New York bar exam, how going back to that type of exam would address some of the concerns that have been raised regarding bias and equity of students, ability to successfully complete the exam. So, one, what are your thoughts on that and your experience with it, with the old exam, if you don't mind telling us? And then two, maybe suggestions on how you think those issues can be addressed. And in particular, one of the things that we have been tasked to consider is the ability of students coming from other countries into New York to take the New York exam, and how that would potentially impact their ability to be successful.
Well, with respect to the concern about pass rates and differentials in pass rates among groups, the point to understand is this, that disparity on its face is a reason to inquire about what the cause of the disparity is. That same disparity, by the way, is what prompted the New York Court of Appeals to commission the psychometrics analysis that was done in '92. They did the inquiry, and when they applied the correct tools, that, by the way, are the tools that the Supreme Court of the United States has said in a couple of important Supreme Court cases, but one of which I want to cite is Connecticut versus Teal, which says you don't look at a snapshot of who's present in the group that passes and who isn't, and look at who they are. You look at whether you're actually making an apples to apples comparison. What the psychometricians found in 1992, and it's consistent with the way of disparate impact analysis is supposed to be applied, is if you compare apples to apples, students, males and females, people of color, people who are white, who have the same educational background, come into school with the same undergraduate GPA, have the same LSAT score, have the same GPA in law school, they pass at exactly the same rates. So actually it turns out that that's what the psychometricians concluded in 1992, that the facial appearance of disparity, once investigated with the kind of evidence-based analysis that the Supreme Court requires, along with common sense, shows that there is not a disparate impact from that exam on people of color or women. The one place where there may be is people with disabilities. And I would say that there's a danger that the next gen exam is going to aggravate that problem. And Suzanne Darrow Kleinhaus is an expert on this. But modality of the next gen could very likely aggravate the impact on people with disabilities that didn't exist in the old New York bar exam. So that's the answer to the first question. The next answer with respect to the foreign educated students, I think it's this committee has to say or acknowledge that whatever alternative model that they may want the court to experiment with will never scale to 12 to 14,000 people a year, in part because somewhere between 30 and 45% of them come from outside the country. And so to dictate, a sort of a certain course, a set of CLE courses and that sort of thing, just is not a viable option for more than a handful of people. And what is inevitable is in 2028, we have to give an exam. I would say we have an opportunity to give it on that second half of the second day. That's going to equalize everybody, no matter what law school they went to, no matter what country they're from. They're all going to be held to the same uniform standard. And I would say that psychometricians need to be engaged to make sure that that test is done in a way that is reliable, valid, and non-discriminatory.
Thank you. And I'll just say that you just shortened our time frame to get our report out, so we have the time for that. I'm joking.
I really recommend reading that.
Just around the corner today.
I recommend reading that
Yeah,
1992 report that's cited in my my testimony, the written submission.
Michael?
Hi, thanks, Ed, and thanks, David, for your testimony. And And I appreciate the way you organized it. So I think your testimony is very clear with the statement of facts. I appreciate that. I actually would like to ask you a couple of questions about things we've heard from others. I think your testimony is pretty clear. You talked a little bit about psychometricians. You just referenced them in your answer to Sherry. The Board of Law Examiners has given us a submission. I don't know whether you've had a chance to read it over the weekend or not. But one of the things they say is there's no need for the board to expend tens of thousands, hundreds of thousands of dollars to employ a team of psychometricians to develop a separate New York law exam. Next Gen bar exam is going to be professionally developed and validated. So there's no need to replicate that with a second high stakes examination. And then they go on to say the local component is not now, nor should it be intended to be a second high stakes bar exam. It's simply a vehicle to educate candidates about the nuances of New York law. It is not professionally validated because it does not test competence to practice law, and it was never intended to do so. I wonder if I could have your reaction to that. And then the second part of my question, if you heard the testimony this morning from City Bar, whether you have thoughts about the online course without a test that's being proposed by City Bar. Thank you.
So as to the Board of Law Examiners' point about the New York exam and what its purpose is, I don't accept that we helped anyone, certainly not the public that the licensing process is designed to serve, and not actually the law students who are really looking to us, the people who are running law schools, who are setting the licensing standards, to say, we'll do what you tell us to do to become competent lawyers. Tell us what that is. I don't believe it does them any good to tell them that knowing New York law and practice procedure is not really important to the more than 80% of you who are going to practice here in New York. I just don't accept the premise of the Board of Law Examiners testimony, which I didn't read, so this may not be an accurate description, that we don't need to be as good at this as we were prior to 2016, when we did test 14 different subject domains that the Court of Appeals had identified through its own public hearings as the correct ones for basic competence. Now, remember, in that report, that 92 report called the Millman Report, they specifically say, we understand that we are not licensing lawyers to be as good as 30-year practitioners or 10-year practitioners. They said, when we evaluate this 1992 exam, we're looking at basic competence to enter the profession. And they said, it is valid, it is reliable, and it is non-discriminatory. The quote is, it surpasses acceptable levels, close quote, in the psychometrics industry. So I don't accept that we had a good one that surpassed acceptable levels, that was working as well as it worked, and that we now should have something that was never tested and doesn't need to be tested because the UBE that tests absolutely no New York law whatsoever will establish some competence in the law of nowhere that will allow the licensing authorities in New York to say to the public, we are adequately protecting you from lawyer incompetence because the lawyers we license, while they may not know New York law at the level of competence that we require, they know the law of nowhere at that level of competence. I just don't accept that that's a legitimate way to frame the question. I also don't understand the resistance, quite frankly. I've worked with John McAlery on the committee, and so I know him to be a very conscientious fellow, and I know that he can pull out of his archives psychometrically validated essay questions and multiple choice questions that will test all the old domains the New York Court of Appeals thought were appropriate. Or if the New York Court of Appeals really wants to say, let's update things from 1992, the first step, go out there and redo professionally under the guidance of a psychometrician, the evaluation of what current New York lawyers need to know to practice. I mean, prior to 92, there were more than almost 40 domains that were protected on the New York law exam. It was reduced from 40 to 14 through a process of holding panels and that sort of thing, public hearings. There's no reason why the Court of Appeals shouldn't do that again. They don't have to accept the 1992 domains. In fact, if they don't want to, they should go out and start that process immediately. to establish the domains. So, and I know John would do that competently and diligently, and he would update the questions that are already sitting in his files. It would also cure the problem of no essay questions on the next gen exam. I mean, it's remarkable that long form legal reasoning, writing, and analysis is not considered to be a fundamental lawyering skill for an entry level lawyer. I didn't hear the testimony earlier, so perhaps if you just characterize it for me, Michael, I could give you a comment.
Yeah, basically the idea is to have an online class, to have it be more interactive some period of time. You wouldn't have a test, but you would have more of an interactive class that would be done completely online, that would sort of take the place of the existing New York law course and New York law exam.
Oh, I mean, that's a wonderful question. Thank you for asking that. So I think the part of the testimony that I heard today from a couple of sources, and I listened in on other hearings, I think there's universal agreement that the best way for people to learn New York law and procedure, and I distinguish between the two because this just isn't about the CPLR. It's about every domain. It's about New York family law, New York trust and estates, New York evidence. I'd like labor and employment, which was on there 40 years ago, to be back in there because not only am I a labor and employment lawyer, but virtually everybody every day is subject to the labor and employment laws, and their rights are being compromised, and we need New York lawyers to protect them from compromising their rights. So I would like those things to be integrated into the 3 years that students take in law school, sitting there in a course, building over time on the knowledge that they learn and interacting with the professors. I think there's no doubt that the best way for people to learn the law is courses in law school, better even than the bar prep courses that the people from outside the jurisdiction take, which are more intense than the CLE courses. So I don't think that by watching videos, even if they're interactive, that's going to be a substitute for law school courses. The next thing I think is, with all due respect to the Board of Law Examiners, and again, I have tremendous admiration for the work they've done and the extra burden that was placed on them by adopting the New York law exam. They aren't educators. They're testers. I mean, they are examiners who assess competence. They are not teachers of law. So to ask the Board of Law Examiners to either create those videos or to supervise the creation of those videos is to ask them, to borrow a phrase I heard earlier, to operate outside their lane, their area of expertise. The place where that ought to be done is in the law schools. And finally, with respect to what Dean Bialik said, I would say this. I love the idea of all the innovative ideas she has. That should be done, that innovation should be done in law schools. We've got 15 of them here. There are more than 160 around the world that contribute applicants to our bar. Let them be laboratories of innovation in all the different ways that they can come up with the ultimate goal of saying, however you get students to this place, let's have a uniform test of New York law that everybody takes under the same conditions at the same time, that reliably and fairly and in a non-discriminatory way tests competence. That way, law schools can innovate to their heart's content. I think actually it's worse to say, now we're going to dictate to law schools how they teach. Specifically, how many hours of a particular trust and estates they want to take, or family law they need to have, or how they're going to grade the students at the end of the course. That actually stifles law school innovation. I think having a bar exam that's rigorous and acceptable to everybody, the public, law students, professors, and practitioners, gives an umbrella, creates an umbrella for innovation.
Thanks, David.
Louis?
Hi, David.
Hey, Ulyss, how are you? Good to see you.
Doing well. Good to see you too. So I have two questions. The first is, we've heard from a number of witnesses about the specific issue of the inability of most students to retain the information for very long after they've prepared for and taken the bar exam. The 1992 validation study that you reference, it seems it primarily addresses the issue of whether the test is discriminatory. But one of the concerns that that's come up in this process is the real marriageability between an exam, a kind of high stakes exam, and this purpose of protecting the public, because from a lot of these witnesses, some of these witnesses that we've heard from, the idea is people prepare for the exam, they have this extraordinary moment of preparation, they learn all of this law, they pass the exam, and then they forget it. And that, many of the same objections that we've heard about lawyer competence, I feel like I've heard them my entire career. Maybe they're different since 2015, 2016. But one of the questions I have is, do you give any credence to the notion that we may have learned some things between how we were testing in the 90s and how we're testing now, or thinking about these things, given what we've learned about the ability of adult learners, or the inability, frankly, of adult learners really to retain this information, that if it's important for the protection of the public, whether there should be sort of multiple tests, should we be testing again 5 years into the profession, 3 years into the profession? Like, is the test really solving the problem that we put to it, right? So that's sort of question one. Question two is, as you were going through the non-testing alternatives, your objections seem to be mostly logistical, about scalability, about whether they're working well in other jurisdictions that may be trying them. And I guess my question is kind of, are there any non-exam alternatives that you think could be useful for licensure, for just, entry into the profession, just, basic competence, entry into the profession? Or is it really just, from your perspective, really exam is really the only thing that we could do that you think would be useful at the scale that we need in New York?
I'm going to answer the second one first. And I'm going to use an analogy to say, I really do think the exam is the only way to do it in New York for this reason. And that's the number 12 to 14,000 applicants a year in New York, compared to those other jurisdictions that have a few dozen or a couple of hundred. They don't even have more than a few hundred being admitted to the bar in their state when they offer two different options, a non-exam alternative and an exam alternative. And here's the analogy. We are General Motors in New York in terms of admitting applicants to the bar and assessing competence. And those jurisdictions, perhaps, that use the non-exam alternatives are, able to sit and maybe handcraft a Rolls Royce. And it's marvelous to think about all the great things you can put into a Rolls Royce, and how you can, polish the burled walnut and, polish the fixtures and make them out of gold if you want to. And that's just marvelous. And I'm sure the people who drive those cars are thrilled with them. But here in New York, like at General Motors, we need to assess the basic competence of 12 to 14,000 people a year. General Motors, by the way, produces 2.5 million cars a year. Rolls-Royce produces about 3,000 or 4,000 a year. That's really the scale we're talking about. It's that kind of disparity. I think the only way it can be done fairly, reliably, and in a non-discriminatory way on that scale is to do it with an exam. And here's the other thing I think that I'm concerned about with the exam, Ulyss, and that is there is so much opportunity for the kinds of problems they're experiencing in Canada to crop up with some of these alternatives, especially if it's an apprenticing or articling alternative. I mean, it just puts new lawyers or new graduates in a subservient position to that supervisor who holds their entire future in that supervisor's hands. And that has turned out in Canada to lead to real problems with discrimination, exploitation, people just not paying appropriately for the hours of work they're demanding, people sort of not being stuck in their apprenticeships because they can't leave, as unhappy as they are on the job, or they can't find one. They have to wait years to find an apprenticeship. They can't practice as a result. So that's why those scale problems aren't just sort of theoretical. They're real, they're concrete, and I just don't see how we solve them here. the first question you had. Euless, I want to correct something that you said about that 1992 Millman report. It didn't principally or even exclusively look at discrimination. That was one of the things they were asked to look at. What all psychometricians do, and what those psychometricians did, was they principally look at, is this exam a valid test of what we want people to know to be basically competent to practice law? That's the first thing they always look at. Second thing is it reliable? Can you reproduce it over and over and over again, whether it's February or July, whether it's 2022 or 2026? Is it, no group is being disadvantaged by taking it at a particular time or at the Javits Center as opposed to the Egg in Albany, that it's reliable across all administrations of the exam? And then they get to the question of, and does it have a disparate impact on particular groups? And it was all three of those that they looked at, and they found it is valid, it is reliable, and it is non-discriminatory. So then you asked, well, are we stuck with 1992? Of course not. You could hire a psychometrician or a team of them to help you build a better New York law exam to slot in on that second day of the 2-day next gen exam, which now is only going to be 9 hours in total. And I would encourage you to do that. I mean, happily, one of the 3 psychometricians from 1992 is still alive and practicing and on the faculty at the University of Minnesota. And although he said he could not reproduce what he did in 1992, he'd be happy to be a consultant to the court, setting up a work plan for how to design, in conjunction with John McAlery and his staff, a really good New York bar exam.
Chris, did you have some questions?
Yeah, I want to build a little bit on Eula's question. I mean, I was a law school teacher for 40 years, and I believe that I observed over those 40 years, not just sort of hopefully my own ability to be a better teacher, but also really very different ways that we thought about how people learn, as well as, I think, an observation of how the students that we're teaching today are very different than the students that we were teaching in 1992 or 1982 or 1972. So the combination of a real body of knowledge about how people learn, coupled with these, this generation of students who goes to Google and who has AI and who have all these other tools that they use, and also all of the kind of stimulants that come from the many technologies that they have been confronted with that affect their learning ability, or that stimulate their learning ability, as opposed to, those of us who had books and went to the library and shepherdized, right, in 1963, as I did. So I really appreciate what the Board of Law Examiners has said, or what I've heard from John McAlery, which is this should be about what people know, and the validity of testing people on stuff that they memorize is very different from ascertaining what they know. And I think we've heard a lot, and there's pretty good evidence that if you teach to a black letter law or whatever test, and people can memorize that, or people can use an open book to get to it, or whatever, that's one thing, and you can have a very valid exam that tests whether they're actually doing that or not. But is that really what we want? And what I've heard, I think, from the Board of Law Examiners is that we're really more concerned in the New York aspect of this, that people are familiar with New York law. And I think it came up in the last testimony as well, as that they know where to look for it. That legal research, which is now so very different from what it was when you and I started, before you, I assume, but when we started out, it is really different. And New York has so many bodies of procedural law as well as substantive law, and so many differences, that knowing that it's all there and knowing where to look is not something that you can easily test, but you want people to know it. And so, how do you reconcile the learning about New York law and New York practice in order to practice with just testing whether somebody can still essentially memorize or utilize an open book system or whatever in a test in a valid way to do something that is actually not what they're going to be doing as lawyers.
All great questions. Let me start with memorization. I think memorization has gotten a bad rap, quite frankly. You and I are probably familiar from teaching with something called Bloom's taxonomy of education. It's that pyramid of how you establish objectives to teach, how people learn and how to teach them to achieve those objectives. It's used universally among education professionals. It's a pyramid with ascending from a broad base to an apex at the top. That base is called recall. If you just Google Bloom's taxonomy, the foundation for every other element of learning and then doing is recall. And recall, of course, is just another way of saying memory. So even Bloom, the expert in education of adults, says, and children, says that you've got to start with recall of basic facts that you've memorized. And then you build on that until the final apex of the pyramid is create. And that's what I think we all want students to be able to do eventually, is create work that's, acceptable and represents clients well. So I don't think it's correct that memorization is inherently bad. I think the opposite, actually. It's fundamental. Next, in 1992, Professor Sackett's report, the Millman Report, they addressed whether that exam excessively tested memorization as opposed to legal reasoning, which is the essence of what we do as lawyers. And they found it didn't. They found it was not imbalanced. So even that old way of testing was not found to overly emphasize memorization. I mean, it has to have some because of Bloom's taxonomy. That's the foundation for everything we do. Next, I would say that what the next gen is doing by saying they are testing skills is throwing out the fundamental skill that especially a brand new admitted lawyer uses for at least a couple of years, and that is writing legal analysis and reaching a sound conclusion that they can communicate effectively to a partner or a supervisor or a client. Next Gen does not do that now. If you even look at their own analysis of whether they require long form, medium form, or short form writing, I think they say the exam tests short form writing 14 or 15 times, medium term once, long term isn't even on the list. So I just don't accept the notion that we can just rely on the uniform or next gen or the uniform bar exam to test fundamental skills even that are essential to lawyering, and certainly not New York law knowledge. I don't think there's no pretense about that. They just don't test that. So finally, I would say with respect to the question of they just need to look up the law, I can tell you that if you don't have a basic understanding of the basic principles from having New York law integrated throughout your 3 years of law school, you aren't even going to know where to look. I was invited to teach by a professor who is a 30-year teacher of employment discrimination at St. John's and a nationally renowned scholar. I think he brought me in because he did not. He trained in Michigan. He worked for maybe a year or two in Michigan before he came out here to teach. He did not know New York law. And he could tell as New York law evolved that New York law was fundamental to anybody's ability to practice labor and employment law here in New York. And that you weren't even going to know whether to look up whether the disparate impact rule is different here in New York compared to under federal law, which it is, by the way, dramatically different, unless you've got some basic grounding in the basic principles, the basic case theories of discrimination law under New York specific law. They wouldn't even know to ask whether disparate impact theory is handled differently here than under federal law. But they will when they take my course, because I am adamant about integrating it. And if other professors are encouraged to integrate it, they will. And the only way to encourage that is to make it tested on the bar exam.
I just want to go back for a second. I didn't mean to suggest it's just about looking up, but it's certainly the case that anything that you learn today at the bottom of the pyramid or whatever could change next year or in 2 years or in 4 years. So I think that what Next Gen is trying to do, whether it's doing successfully or not, it is really explore the larger question of legal research and how one does it, and understanding that New York specific legal research is different from the legal research of nowhere. And that if what we are concerned with is that the people we are licensing to practice in New York, many of whom will not practice in New York, right? I mean, most of these foreign graduates are not going to be representing small clients in upstate New York or poor people in New York City or other metropolitan areas or whatever. But the graduates of New York law schools are, and the graduates of some neighboring states are, that giving them the foundation in this notion of the pyramid about how you go about researching and understanding that is something that I believe that they could learn in an online course. And everything you say about like the wonderful things that you're doing, and I'd love to take your course, and everybody should, obviously. It is sort of dependent on the law school and dependent on whether students think it's going to benefit them or not, given all the competing choices they have. So the idea of the seriously thought out course using all of what and all of what really wonderful legal educators, many of whom are in New York State, know about learning, to create and craft a really thoughtful course that gives people the basic foundation of this that they can draw on long after they've forgotten the jurisdictional requirements of filing a petition in surrogacy court, or the different disparate impact rules in labor law. It seems to me that's what I was trying to get at, not sort of memorization of facts, but in testing, we're testing something. People can learn what we're testing, and then they can learn to do well on that test. But if we want them to really learn how to be lawyers, and we want them to learn how to be competent lawyers in New York, then the tools that we give them to learn that, I think, are, and again, I go back to the Board of Law Examiners and to John McAlery's statements about this. It really seems to me to be important, and I just want to make clear that I'm not just talking about memorization.
I'll just say I want to make it clear, Judge Glenn, that I'm not saying get rid of the uniform bar exam. I'm saying that what was done in shortening the uniform bar exam to 9 hours and shifting its focus to skills-based testing gives us here in New York a really golden opportunity that will be here, I think, once, and then it'll close in 2028, to insert on that second day a test that is going to test legal reasoning and analysis skills, writing skills, and knowledge of basic New York law principles across whatever the domains are that the Court of Appeals decides are the essential ones to know in New York, whether it's the old 14 or a new 14 or 10. And that when we tell students that's what they need to do to pass the New York bar exam, and by the way, I would keep it separately and independently graded. I wouldn't integrate the score on that exam with the UBE score. I don't even know how that'd be possible. But because it's separately graded, I think that the students will say, the people who've practiced for decades in this state are telling me I need to know New York law to practice effectively and competently in New York State. And I'm going to ask my criminal law professor, I'm going to ask my T&E professor, my family law professor, my labor law professor to teach me the New York rules so that I hear them at least and can compare them to the federal rules or the law of nowhere rules. And then if they don't do that, I'm going to go to my dean and say, Dean, I need you to make sure New York law is integrated in all the courses that I take in law school, not just in one course I take in my second semester 3L year, or 2 courses, one in the CPLR and one in, New York Smorgasbord. Because I don't think just tasting the New York Smorgasbord, which is a little bit what the New York law course is now, is really the effective way to learn. I think you do have to immerse yourself in it, talk to your colleagues about it, talk to your professor about it. And finally, and I want to go back to this point because I think it's an important one, I think all the innovative work that law schools can do, and I think they're tremendously capable of doing it if they know they have to innovate integrating New York law into the curriculum will be phenomenal, will be a phenomenal boon to everyone, but most importantly to law students. Because as Justice Dillon said in the article that he and I collaborated on, when a New York brand new lawyer stands up in the courtroom in front of a lawyer who's been practicing for 30 years, the court treats them exactly the same, expects them to behave exactly the same, holds them to the same standards. I think we're making a mistake in telling law students, you know what, you'll practice for a few years and you'll get there eventually, maybe 10, 30 years from now. They need to be ready out of the gate to do the basics and not embarrass themselves. I mean, think how terrible it is for them to be embarrassed like that publicly in a courtroom when they don't know the basics of the law. And I don't think that you mentioned, Judge Glenn, that students are learning differently now. I think that's true. But I fundamentally believe people don't change that much over time. The students I teach today are just as smart as the students 20 years ago or 40 years ago. What is different today is we're expecting different things from them today than we did before. And one of the things we're telling them is we have no expectation that they'll be knowledgeable in New York law and procedure. But then we're putting them out in practice, hanging out their shingle on Queens Boulevard or in the courtrooms saying, all of a sudden, you better know New York law now, right this moment. You don't have time to look it up.
Thank you. Any other questions? Okay. Do you want to take a break now? Do you want to hear from more folks? Where's everybody? How's the committee feel about it? We're running behind pretty good.
I apologize for that, Judge Carney. Thank you for letting me.
This isn't directed at you, David. We appreciate your time, your effort, and all the information you gave us. This has been wonderful. But we have so many people that want to testify today. I'm sure trying to figure out how we're going to manage it. But no, thank you so much. We do appreciate it.
I would suggest that we continue and that if people need to step away for a moment, they step
Sure.
away
How's that sound?
unless other people feel different.
Okay. Let's keep going then. So our next individual is, and we appreciate your patience as well, Professor Daryl Kleinhaus.
Well, thank you. It was a pleasure to listen to David, and much of what he mentioned, some of the topics that I'll be taking up in somewhat different way, but he also provided a really neat segue for me to carry forward with what he said on certain levels. He addressed a number of important issues. But first then, I should also tell everyone, because not everyone knows who I am. I am a professor at Touro University, the Jacob D. Fuchsberg School of Law, where I've been a full-time faculty member since 2000. And for many years, for 18 years until 2021, I was the director of academic development and bar programs. So that I have an immersive history in what we are talking about now. Since 1998, I've been preparing first-time bar candidates and retakers for both the prior New York bar exam, which is the one that I took, and the current UBE. In fact, I'm working with 4 students now who are preparing for July's bar exam. So I know firsthand from working with hundreds of students over the years exactly what goes into preparing students for the bar exam, and especially in working with retakers, which lets me understand why and for what reasons they were unsuccessful. So I've been doing this for over 25 years. I also have taught bar exam tested doctrinal courses for 1L students. I teach contracts and I teach upper level sales course. I've also written extensively in the area of the bar exam. My first book was The Bar Exam in the Nutshell, which is now in its 4th edition, and I won't be writing another one of those until it's about Next Gen. The Next Gen UBE, that's its formal name, and I'll be using that when I speak with you. I've also published one of my favorite books, which was all about the New York bar exam, which I had studied. It's called The New York Bar Exam by the Issue. And I took it apart issue by issue because I've studied every bar exam since 1998, the New York, the current UBE, by the subject and by each issue that was tested on each administration of the bar exam. I've written Acing the Bar Exam. I have written the Short and Happy Guide to the MEE, and I've also written a number of articles about the bar exam, and I put them beginning with a response to the SALT statement on the bar exam, which was in the Journal of Legal Education 20 years ago. And I'm hearing some of those same arguments and some of those very same discussions happening now. And so, like then, I can say the same thing that like then, I'm saying the same thing now. There's a purpose for a bar exam. There's a purpose for a licensing exam that is separate from other things we can talk about and the things that are the job of the law school. Exams serve their purpose. When I talk about an exam, there's law school exams which serve their purpose, that we need a purpose. Why do we test our students to begin with? There's a purpose to an exam, and there's a special purpose to a bar exam, which I'll be discussing. But it's a different purpose that exams serve from law schools. And as David said, and the speaker, I think before, the former dean of CUNY, I mean, law schools can do an awful lot. Law schools have a vital, exceptional role in preparing law students for the practice of law. If it weren't for that purpose, that's what law schools do. And so some of the things that we'll be discussing in these alternate pathways to licensure, calling for things that they should do instead of taking an exam, those are things that law schools already do, or they can do more of to prepare them in those practical skills. Doesn't replace the necessity for an exam. So, but the first part of the exam that I want to talk about, which I don't think anyone has raised, is the question that is to tell you and share with you if you don't know, because I'm finding a lot of people do not know this, that the Next Gen UBE's test modality will be fully online. There are no hard copies of the questions provided to test candidates except those who specifically qualify for that accommodation based on a disability. So they will not be taking a paper-based exam for the questions. I'm separating out now the questions as opposed to typing answers, because for years we've known, and I really do think it's an improvement, to be writing your answers, not in a blue book or whatever color the color of the day, but typing your answers, because when you're typing out answers to essays and especially the multi-state performance task, you need to type. You need to type. It's an important issue in terms of completing the exam because these are very lengthy responses. But in those cases, at least you have, and currently we still have paper. There's still a paper modality. But many of us are concerned as educators, and especially the students with whom I share this information, the students in my classroom, when I tell them that the Next Gen UBE will be fully online, they look at me with widened eyes and say, how is that possible? So I want to share with you the research that I've done and the information that I would recommend this committee advise to the Court of Appeals to think long and hard about this and perhaps request some information and some data before proceeding to adapt what NCBE has on its own identified as the modality. There's no data that I've seen, and I've not seen it raised in any document anywhere about asking any jurisdiction about a preference or how we wish to administer the exam. So we have not seen any data from NCBE to support this movement to go online. What we do know is that we have a 9-hour high-stakes licensing exam with dense reading materials. There are still over 100 multiple choice questions. There are integrated question sets, which if you've looked at the NextGen website to see what these questions look like, and I suggest that members of the committee should really look at what we see as integrated question sets where there are excerpts of testimony, there are materials to be, statutes to be read. These are things that the candidates now are going to be scrolling back and forth on their computer as they read through material, then have multiple choice questions that must be answered, and then they have to scroll back to look again at the relevant excerpt or information that they were given in order to answer the question. So the fear now is that this delivery method will impact performance because of the time needed to scroll back and forth through the computer to read and answer these types of questions. And it's of equal concern whether or not the need to read text on a computer screen and then navigate within the document does or doesn't impact reading comprehension. We know that all tests have speed, they call them speeded exams, right? All tests are speeded exams. And speed is a variable in any timed exam. It cannot be, however, that an examinee's facility with the exam's modality, the very modality on which they're taking the exam has any more than a negligible effect on that examinee's score. Are we testing them on law, whether New York or the law of nowhere or any law? Or how with ease are they with the computer and with the modality on which they're taking their exam, and which NCBE has just released last week some new guidelines on using the software program that they will be using. It is not ExamSoft. They've adopted a new software program, and they have guidelines on how candidates can use the software to highlight, things they want to remember, and how they can use a notepad, and how there may be other things for them to use, all in place of a piece of paper and a pencil to take notes or do what you need to do and mark up your test questions. Now they have to learn how to do this together with all the other anxiety of learning the law on how to use the modality on which they can answer their questions, on which they must answer their questions. So I ask, how is that a new variable that needs to be added to the candidate's level of knowledge and anxiety? So in addition to a problem with reading the material online, it might also affect their comprehension and performance. So and then there's the other recent announcement that was made by NCBE that the candidates, while they will be taking this in a proctored exam environment, they are to bring their own laptops. They are not using standardized laptops where everyone has the same laptop. Well, this means there are countless differences in screen sizes and processing speeds, which could necessarily create advantages to some at the expense of others. We have not considered, and we do consider in all aspects of the bar exam, or really any exam, whether there are disparate impacts. Well, here is one that I see daily in my classroom. I'll discuss that in a moment. But right now we know that those who can afford to purchase new laptops with greater speed and larger screens would be at an advantage over other examinees who could not possibly do so. And that widens economic divisions. And so these are factors that affect the consistency needed for a fair, valid, and reliable exam when we're dealing with high stakes testing. We have made rules at the law school level because we have seen so many of our students trying to taking multiple choice tests and other multiple choice tests on their iPhones. And so we've banned that. So they can't use other kinds of smaller version. I don't even laptop things. I'm very technical here, but excuse me for that, because there are just so many different versions, like iPods or ones that you would just read on. We tell them you must take it on your laptop. So I teach approximately 70 to 100 students each academic year, depending on the size of my first year class in particular. Last year it was 55. I've taught as many as 70 in my first semester contracts class, and practically every student does use a laptop to take notes in class and write their essays for the final exam. But some students have noticeably bigger laptops with larger screens, but most of them are small. I don't even see how they do it. I wouldn't even be using that to take notes and look at the PowerPoint slides that I distribute in class, and they split their screens into tiny pieces. But they're small because they carry them to every class, and they carry them in their backpacks together with all their books. I don't see how it's feasible or even fair, in the widest sense of the word fair, and equitable to use such a laptop to read and answer questions while scrolling back and forth on a 9-hour licensing exam. I continue to give my students hard copies of all the questions on the exams that I give them, and they can type their answers on ExamSoft, or they can use Blue Books if they prefer. Almost every student chooses to type their answers. I'm grateful because I can read it with greater ease, but they are grateful that they have the questions in hard copy for both multiple choice and for essays. And I collect all their exam booklets afterwards. I collect the papers that they annotated, and they take rigorous notes, and they write all kinds of things on the question sheets that help guide them. I like to see their thinking, and so I can see what they're thinking as they go through questions when they mark them up. None of that is going to be available to anywhere near the same degree when they're taking the most important exam of their life. So I ask that if there is a difference in test modality that raises even the slightest question as to whether it impacts performance, then additional research is required. All we have now is an assumption that there's no difference in examinee performance, whether the test modality is fully online or provided with a paper-based question. And such an assumption warrants substantiation, since a licensing exam should not be based on conjecture or impressions. And it's especially the case when measurement experts who study the impact of timing on power tests in educational settings have identified time-limited tests as, and now I quote, less equitable. In addition to excluding students with documented disabilities, tests can also impede students who are learning English, students from underrepresented backgrounds, students who are older than average, and students with disabilities who encounter barriers in obtaining disability documentation and legally mandated accommodations. As I said, it is not easy, first of all, to get accommodations, and now these accommodations would have to identify specifically the need to have a paper copy of questions as being specifically connected to the type of disability that the person has. In June 2021, when I was a member, as some of you were, on the New York Task Force on the bar exam, we were one of the first to raise concerns with the National Conference of Bar Examiners' intent to administer Next Gen fully online. And we discussed findings of scientific studies that found that, quote, the shift from distributing text materials from print to digital in the form of PDF files has negatively impacted comprehension. Perhaps due to characteristics of the computer screen, with its refresh rates and high levels of contrast fluctuating luminance, comprehension derived from computer-based reading is not as great as it is when derived from paper-based reading. A study of 15 to 16-year-old female students in Norway reported students who read texts on paper performed significantly better than those who read texts on the computer screen. There have been other studies done as well. But to date, NCBE has not released any data to show that there is no difference in examinee performance when taking a 2-day high-stakes licensing exam involving the type of dense reading material that they will be testing. And this is very interesting because in the most recently released blueprint slides, is what they call it, from NCBE, which just came out a couple days ago, it gave us more information about what we can expect on Next Gen UBE. And it also noted, NCBE also noted, that they have had 3 pilot testing phases. And they released the number of students, both 3L and 4L, and some practicing newly licensed attorneys, those who recently passed the bar exam. How many of those formed the participants in their pilot testing? So in the first pilot test, there were 2,500 students. In the second pilot, there were 4,000. And in the third pilot, there were 2,000. So doing the math, which, like any good lawyer, I don't like a lot of math, but this one was pretty simple to add up. 8,500 students or candidates were tested with the questions that are proposed for Next Gen UBE. Not one word has been mentioned about whether in testing 8,500 students under timed conditions and using the questions that they're preparing for for the debut in 2026, not one mention has been made as to whether or not they tested to determine whether there was a difference in performance between those who took this fully online or had questions on paper. I find that problematic when NCBE has psychometricians and uses them and creates a wonderful, and I've said in my report to the committee that I like their exams. I've never questioned their exams. I think that they go through a rigorous testing for validity and they confirm it with psychometricians. I may have had other issues with how they may grade it, but now the grading will no longer be an issue. There will no longer be relative grading on the bar, on the UBE Next Gen, because they've eliminated, as David referred to, and I will discuss, they've eliminated essays. Essays were what they used to use the relative grading for. And what will be interesting for you to learn is why there's no longer any need for relative grading, and they can use very carefully designed rubrics. And that way they told us that, while relative grading is a fair measure, this one is even going to be better. And they've written articles about that in the Law Examiner. But here, when we don't know whether or not there'll be a difference in the outcome on something so central, then we need to ask that question. Because the only data that we do have, that of course didn't come from NCBE, came when we had to give exams online during COVID. And the states of Arizona, Idaho, and Texas being a non-UBE jurisdiction, compared the results from tests taken for their July and September 2020 bar takers. They looked at the differences between those candidates who took the exam in person and had hard copy of the questions, and those who had to take the exam fully online. And they found significant differences in the pass score. For Arizona, taking the UBE in person, 80.7%, 399 students passed. The online rate in October was 44%. There are significant differences, and I won't trouble you with all the data. The data is available, but the data that we need, we don't have. The data that we need is to know what we can expect if all of the exam goes fully online. But even the small sampling from 3 jurisdictions show that the difference in pass rates between in-person and online pass rates is too great to be ignored. We cannot ignore this. And I would, once again, I asked in what I wrote, I asked that the committee strongly recommend finding out. First, go ask NCBE. They should be asked. Did they take the data? And if they took the data, then why hasn't it been made available? If they didn't take the data, why didn't they see that there was a need for the data? When studies in general education over the last number of years has shown at different levels, there are marked differences. And this is not just the United States, it's not just teenagers, it's across the board. There are differences in taking exams online, purely online, versus having paper. I see the differences in my students who now use casebooks only online, as opposed to those who have and buy the more expensive textbook and mark things up in their casebook. The move to this online modality has had consequences. I see that in the learning in the classroom. I have no doubt that it would make a significant difference in bar exam outcomes. I also urge, if they can't ask, I don't know how the committee would find out, but if NCBE is not willing to share this, there were all these 8,500 students. 8,500 candidates took these pilot exams. They would know if they were even asked. You just need a small sampling to find out. Were you asked whether or not you were going to take the pilot test in hard copy or on paper? The students would know. The candidates would know. So I urge, once again, I strongly recommend the committee engage in its own independent psychometrician to gather and evaluate the data that's available and ask to see what is further available regarding testing in these two different modalities. I'd like you to know that to date, the only reason given for the move to the fully online test modality are two concerns. One is the concern over exam security, keeping the bar exam safe, and the other are the costs of a paper-based exam. Well, I don't find it credible that an exam that has been given for decades on paper, I'm sure every one of us has taken that exam on paper, has suddenly become subject to security and increased paper costs. It's far more likely that the security issues are with online test modalities to begin with because of increasingly sophisticated cheating methods. I'm not questioning whether there's been cheating on the bar exam. I know that we do a very good job of it, but now there are other ways to access software programs online from what are called, regardless of your physical location, from remote accesses. There are more sophisticated cheating methods out there. So I'm not concerned as much about a cheating issue, but this paper issue. Since, we've had paper for 50 years, I don't understand why we can no longer have paper. And so as to the price of paper exams, I don't know of any new tariffs that have been imposed on paper. So paper is not any more expensive than it has ever been to give an exam. And in doing some research, I've learned that New York has one of the least expensive application fees at $250 for the first-time bar taker than any other state that gives a bar exam. Other states.
Professor, if I could interrupt,
Yes.
we have 7 other folks that need to testify today, and we allotted 15 minutes for each speaker. We really value everything you've said today, but it's the hour's getting late. Yeah.
Consider the price of paper. It can be, if we can afford it, we can increase the price if we need to for taking the exam in New York. My main concern next deals with the pathways to practice, and I know that you've heard quite a bit about this, and you've heard a bit about it today. So I'm going to raise an important issue regarding the single issue that I haven't heard raised about the diploma privilege, portfolio practice, or supervised practice. How is that measurable? No one has raised the question or even asked the question, let alone answered the question, is how are we going to make various versions of this kind of pathway to practice measurable to achieve the psychometrically approved levels of reliability, validity, and consistency necessary for any licensing credential? The proponents of these alternatives have glossed over the measurement issue and focused on the good things that these alternatives can do. And I'm not saying that they won't do good things, but there are other ways for them to do good things during the 3 to 4 years that law students are in law school.
Yeah. Excuse me, Professor. Sherry, do you have your hand up?
Yes, I just wanted to ask a quick question, and I think maybe if it's okay, we can turn this to questions because we also have your written testimony so that we can move on to the other speakers who, because we're like an hour behind at this point, if not more, and I apologize to the speakers who are waiting. Not your fault at all, Professor.
I
Not,
understand.
please
Please
don't
call
take
me
it that way.
Suzanne.
But my question is simply this, and I understand, I'm hearing your concerns and I understand your concerns. I wonder if you have considered the fact though that this generation that's coming forth has done everything on computers. They read on computers, they go to school on computers, they are on computers all day. My kids, and they're all grown and out of school, and they didn't, when they were in middle school and high school, everything was online. They barely had textbooks. So I just wonder if you consider that. And I wonder if you have any information about how that would impact the argument that you're making about the reading, paper versus computers.
I know about that. I've thought about it, and I have firsthand experience because, like you, each year I am shocked by the students. My first year law students are not as savvy with tech as you think that they are because they don't separate from their cell phones. Yes, they are great with texting. They fly by, but they are not great with other modalities that we ask them to use in law school. I do see differences in their reading skills versus when they're reading online versus the way that they used to read, because I've been teaching for a long time, and I've noticed a significant difference in the past 5 years with how students do read. In fact, I just completed a research study for Access Lex with dealing with issues with reading comprehension and dysfluency in law students, which has never been looked at before. So I've been studying reading and dysfluency, and I see that there is a connection because my students, we do things online. I provide the slides on Canvas. Everything is on Canvas. My students can't seem to work with Canvas. I thought since elementary school and secondary school, everything has been provided to them online, but they're not as savvy as we give them credit for doing in terms of finding what they need and using that material. I have seen problems where I ask them to read out loud with reading skills, and I've seen the differences in how they trip over words. So and not all the people not everyone taking the bar exam is 25. We have ages in our law school from 20 to 60, and they come from all backgrounds. So everyone taking the bar exam may not be as savvy as what we see in junior high and high school and college, or what we presume to be so knowledgeable. Yeah, they're great at texting and they're great at other skills, but not necessarily what we need to take a law licensing exam.
Yeah, excuse me, Professor. We're getting some comments from the other folks that want to testify today, and we really are
Okay.
running short of time. Mike, do you have a question for the professor?
Yeah, I'm going to be very quick. Suzanne, nice to see you again. Thank you for your
Nice
testimony.
to see you.
I just want to focus on one thing that you said, and it's contrary to what the Board of Law Examiners is saying, and contrary to what we were told by one of the deans at our last session. You talked about essay questions and said NextGen eliminates essay questions. The Board of Law Examiners specifically says, no, it doesn't eliminate essay questions. And basically they're saying, well, there are short answers, there's some requests to write as part of the different modules that are put together. Could you explain the sort of this issue, why you say there are no essay questions and why it matters to us, and just briefly?
There's not a single IRAC-based legal analysis on NextGen UBE. They have substituted integrated question sets where the answers may be, the longest would be a paragraph, where it's directed in terms you're given the issue and you're given the materials like excerpts of law or a statute of law, and you're asked to respond very directly to that pointed question. That's why the whole grading system now will be very different. There can be very detailed grading rubrics where the answer is exactly on point or it's not on point. It'll be much easier to grade. And the law exam and the bar examiners have written an article explaining why it is easier, why it will be easier and different to grade and be far more objective. That's because the way they're creating the questions can be graded that way. Even if we look at the performance tasks, and there are three performance tasks in Next Gen, but not all of them, they're 60 minutes long. They're not the 90 minutes of what we have now, which is the multi-state performance test. They're shorter, and they also can involve integrated multiple choice questions together with short written answers. There is not an essay requiring that the candidate read and identify for themselves what is the issue, what are the rules, knowing the rules, identifying the rules from their own head, writing them down, and analyzing a set of facts that they are given. That is not on this new bar exam at all. And you can look at what they're providing. They're good questions that they're coming up with. I've said that in my report, but they do not address this long-held, basic, structured legal analysis that all lawyers engage in post-practice. They're not given everything to them, even in a short task that says, these are my issues, here are the relevant rules, some may be irrelevant, here are the rules, here are the facts that I've gathered, now answer these 2 questions. That is not on the bar exam.
Thank you.
Thank you.
Thank
Okay. We appreciate your time and your
Thank
testimony.
you for asking me.
Thank you. Okay, our next individual that's going to testify today or speak is Brian Kerr, a recently admitted attorney. Mr. Kerr, are you with us?
Yes, I'm here. Can you hear me?
Yes, good afternoon.
All right, thank you for having me. My name is Brian Kerr, and I'm a recently admitted lawyer. Thanks so much for the invitation to testify here today. I'm honored to be here with all of you. I'm a 2020 graduate of the Elizabeth Hobbit Pace University. I'm admitted here in the state of New York in this great state of Wyoming. I'm secretary of the NYSBA Young Lawyers Section, a member of CLIAB with Suzanne and David Marshall. I'm a member of several other bar associations, but I'm testifying on my own behalf. This matter is important to me personally. It's part of the reason why I'm applying for president-elect of the New York State Bar Association this year for the 2026 to 2027 term. Bar associations and other organizations could have had an increased impact on the New York State bar exam process, but decided not to for whatever reason. I was hoping that the committee would have at least one member who is a recently admitted lawyer to increase diversity and hopefully offer additional perspectives. Instead of discussing the problems, which we already know, I will try to give specific recommendations. To start with background, I'm a supporter of the uniform bar exam. It offers test takers the portability between jurisdictions and gives bar examiners the flexibility to make their own admissions requirements. I knew that the Court of Appeals would adopt, or I believe that the Court of Appeals would adopt the Next Gen bar exam, even in the beginning of the Next Gen bar exam discussion. I did not initially agree with the adoption, as I'm a supporter of the uniform bar exam and felt that there were too many questions, but I applaud the Court of Appeals for timely adopting the Next Gen bar exam. The New York Law course and New York Law exam require major improvements. The New York Law exam and the New York Law course test entirely different questions. When I took the New York Law exam, there was not one question that I remember being discussed that were in the videos. Additionally, the materials, including the videos, can be revised more frequently. The New York Law course is more rigorous than the New York Law exam, and the New York Law exam is just a test of how to tab an outline rather than a test of New York legal principles. It's been called a joke by many law students, including myself. It seems as if many law students won't take it seriously. When I was discussing that I passed a New York Law exam, the professor stated that he believed that no one ever failed the New York Law exam. To offer other perspectives, the state of Wyoming has no test on state-specific law, but there is an emphasis on having law students complete internships, externships, and other opportunities to learn state-specific law. Other states such as Wyoming have a better lawyer admissions process and practice environment than New York in certain aspects. If the committee is inclined to recommend keeping the New York Law exam, there are fewer specific recommendations to consider. make the New York Law Exam a closed book exam and increase the minimum passing score to from 30 questions to either 35 or 40 questions out of 50. While students will take a closed book exam more seriously, have many topics tested on New York law and not just the CPLR, emphasize the differences between common law and, like in a majority of jurisdictions, in New York law. As a member of CLIAB, I recently created a list of potential topics for the New York Law Exam. Have digital security for the exam, such as the New York Uniform Bar Exam in October 2020, when a video of the test taker is taken to review for any indiscretions. I would not be surprised if there are students who cheated during the New York Law Exam, as the New York Law Exam has almost no digital security for integrity. If the committee is inclined to eliminate or alter the New York Law Exam and recommend other testing methods, there are many other options. There could be practical tests like conducting legal research, interviewing and advising a client, or arguing a motion with lawyers who evaluate the examinees. There could be writing assessments on New York law, as the next gen bar exam has no substantial writing requirement, such as essays or the MPT. The writing assessments could include drafting a letter to a client, a motion to a court, or a contract for a transaction. I know that finances are a factor, but the notion that students might feel like they're studying for two separate bar exams has to be considered as well. The possibilities are limitless. Jacob Petterchak, immediate past chair of the New York State Bar Association Young Lawyers Section, is an incredible and amazing leader in bar associations in the legal profession. He asked if I could share his comments on his behalf with all of you here today. New York will now have changed its bar exam twice in 10 years and nobody is satisfied. The bench and bar are not pleased with the quality of practice from new admits. New admits are frustrated by the cost and perceived pointlessness of an examination that has become a ritual. The test makers and bar prep companies are happy with their apparently good pass rates, cash flow, and profitability. I spent the last few years promoting the work of the New York State Bar Association to young lawyers across the state as an officer of the Young Lawyers Section. Reaching out to the COVID generation of law school graduates is a depressing thing. The experience was miserable. Classes and final exams were chaotic. Remote internships were rudderless and personal and of little value on Zoom. Relationship building was difficult, and the entire time period was isolating and literally damaging to most people's mental health. The coup de grace was a failure of bar regulators across the country to make any accommodation to the rigid, with some exceptions, in-person examination process. If there was ever a time for emergency diploma privilege, it was during a once-in-a-lifetime or century pandemic, and that just didn't happen. On top of this, legal education costs have been bloated for decades, and law school graduates leave law school after spending hundreds of thousands of dollars on tuition just to find thousands more in out-of-pocket costs to take the bar exam and actually start their career. Once you're so deep in debt already, what's a couple thousand more anyway? I can't overstate how many people that harbor ill will towards their professional regulators and bar associations about that. The ball was dropped. It's so grim out there. I wonder how it got this way. Choices were made, and in hindsight, they were all clearly the wrong ones. Opportunities to make meaningful reforms were missed. We quit doing big things in this country a long time ago, from my perspective. That said, after the other meltdown of the new California bar exam earlier this year, I'm worried about this state's, or indeed any state's, ability to do something big, like make a new modern bar exam from scratch, or worse yet, I'm worried that its failure to execute could throw the careers of an entire class of lawyers into purgatory. In light of that catastrophe, along with much frustration I've heard from examinees seeking disability accommodations, I think one thing is certain. We need more than one single pathway to admission than just a semi-annual standardized test that does not even test the law of New York. Fredonia is not a real place, and people stopped getting that reference years ago. I wish we could start from scratch and put a new exam system in place immediately. It's not how life works, but if we were to do so, I wish we could check in on the paths our fellow lawyers take outside of our own borders and see what they do that works well for them. A near universal feature of legal training and admission to the bar worldwide is something that we simply do not do here. Apprenticeships. In almost every other country, new lawyers serve a term of apprenticing under seasoned professionals, usually between 6 months to 2 years. You learn by doing. Another thing which is really an American aberration is the fixation on standardized tests. We overdo it here so much so that it is hard to imagine anything else. But practicing law is not multiple choice. I know how English solicitors are examined, and the tests are primarily practical. You interview actor clients, do research, write court documents, and argue in mock hearings. They test examinees on how they practice the real local law, not that of Fredonia. Most countries also have multiple legal professions and thus multiple routes to practice law. Advocates who go to court follow litigation track. Notary lawyers who advise transactional business instead focus on that. Their training and examinations reflect a more precise scope of their career. Not everyone is going to be a litigator. We don't recognize that reality in the slightest. So if I had to go down, this is Jacob still. So if I had to go and put down a list of key reforms plotting the way forward, this is what I do. 1, build a program for new lawyer standards. The expectations of a standard or skill of a new lawyer are not being communicated at all. It does not exist. A committee from the bench and bar needs to lay it on detail what skills a freshly admitted lawyer needs. This should not be limited to potentially endless black letter law topics and should include soft skills like client care, interpersonal skills, time management, research, and writing. Exceptions need to be reasonable and measured for outcomes on day one, not that of senior practitioners. 2, create a diploma privilege, or rather a certificate privilege. The 3rd year of law school is a complete waste of time and money, as if law school wasn't already obscenely expensive. New York has 15 law schools. Accredit them to issue certificate in year of practice that exempt recipients from the bar examination. The courses leading up to this certificate should be rigorous, perhaps even a year-long 6 to 12 credit classes on New York practice. Make mock hearings and practical examinations a key part of the courses instead of rote learning. The cost for this would be minimal to the state students already paying for school. 3, bring back a New York bar examination, but get rid of these ridiculous standardized tests. Life is not multiple choice and it does not occur twice a year. The state spends millions to test law students in convention centers across the state for exactly 4 days a year. Set up a permanent test center in Albany and bring in a small number of full-time staff to serve as actor, client / judges and to proctor smaller groups of students year-round in practical examinations. 4, split the profession up for major practice areas for property, family / matrimonial small claims work. It will create some degree of competition in the marketplace. I won't dwell on that here. I already know it's going nowhere. 5, finally, apprenticeships need to come back. Our greatest legal minds were produced this way. Luminaries like Abraham Lincoln and Daniel Webster. Some people do not test well, either due to anxiety or learning difficulties. More importantly, public opinion is behind apprenticing now more than ever, and for good reason. There needs to be a safety valve on costs and accommodations. We don't have one right now. Furthermore, with large swaths of the state's rural counties at risk of becoming legal deserts, this might be an excellent opportunity to offer apprenticeships to underserved geographic areas, directing talent where otherwise would not go. As a caveat, my position is that all of these could and probably should exist alongside continued use of the next gen bar exam, either administered locally on a much more limited scale or by accepting transferred scores from other states. Since there have been
Excuse me 1 second. Sherry, did you have a question?
I have a question and a suggestion. Brian, are you still reading from Jacob's letter? Are you not? Can you hear me? Can you not hear
Brian,
me?
can you hear? Mr.
Hello?
Kerr?
I believe.
Can you hear me?
I think
Yes.
he's frozen.
Uh,
I'm almost done.
yeah, I think I was gonna
Yes.
say, because if you submitted the letter to us, then I would suggest, if it's okay with you, that we go to question.
You're breaking up on us, Brian.
Yes.
I don't know if that was a yes to what I
I'm here.
suggested or not.
All right, I'm here. Can you hear me?
Yes.
Yes.
Okay,
Okay.
okay. Is that okay with you? Because you've submitted the letter to us, right? So.
Yes.
Right. So rather than continue to read the letter, is there anything else that you want to offer from your testimony that we don't have in writing, or can we go to questions?
You can go to questions. That's really about it.
Okay, does anybody have any questions for Brian
I
Kerr?
do.
Okay.
I
so
do.
okay.
First, Brian, thank you very much for, taking the time to be here, and it's really important that we're hearing from new attorneys. So I really appreciate your time and your passion for it, which is obvious. And I know Jacob well, and I'm very happy that he submitted testimony as well. And I agree, he's doing a great job with bar leadership.
Mhm.
My question for you is, do you have any thoughts or reactions to the comments that were made earlier, comparing how reading comprehension on a computer screen versus an actual test, a paper? And do you have any thoughts or feelings about it from you and your colleagues about that? Going straight, does it matter to you all? Do you generally think that law students these days want to read a paper versus a computer screen, or vice versa?
Yes, I mean, personally, I'm kind of like weird about it. Sorry. Multiple choice, I prefer paper because I can like jot little notes down. But for essays, yeah, I think having a paper option would be good just for essays. But typing, my handwriting's atrocious. Like I cannot write an essay by hand. I would have to do it on the computer. So I think with reading comprehension, I think everyone has their own style. Like for me personally, I like paper, even though I feel bad for the environment. But I think it should be an option that paper is given to students versus a computer. Because I know, sorry, but the uniform bar exam in October 2020 was hard to like toggle between like 3 or 4 different tabs while writing an essay. It was difficult.
Thank you.
Thank you. Okay, any other questions
you.
for Mr. Kerr? Well, thank you so much. We appreciate everything you've done today, and we're going to move on to our next individual, Warren Goodman,
Thank you.
Pace Law University. Warren Goodman,
Hi, I'm here. Thank you.
how are you?
Thank you so much. Hi, thank you so much for giving me the opportunity to speak today. I think the work that you all are doing is really great, and I appreciate being given the opportunity to speak and provide my perspective as a recent law school graduate alongside all these distinguished speakers. So just briefly, my background, I graduated from Pace Law School, summa cum laude, 3 weeks ago, where I was a full-time student and a member of the Pace Law Review. I attempted and passed. Thank you very much. Thank you very much. I attempted and passed the New York Law course and New York Law exam in my last semester, where I also was a student in a very undersubscribed 4-credit New York practice class. Prior to entering law school, I worked as an investigator with the New York State Department of Transportation. So I was coming in as a non-traditional student, about 10 years older than my peers who were coming in directly after their undergrad. I'll be taking the New York bar in July, and in the fall, I'll be starting work at the firm Jackson Lewis. So I had 3 main things that I wanted to discuss today. First, in my experience, the New York Law exam did not function as a meaningful test of basic competency in New York law or demonstrate readiness to practice in New York. And from discussions I had with many of my classmates, I can say this is the typical experience. Rather, it is seen, as Professor Marshall put it earlier, as a mere chore. It's something that is crammed for over the course of a week or two, then the material is promptly forgotten as the student goes back to studying for their classes or whatever else they were preparing for. Personally, I viewed the 17-hour New York Law course video modules over the course of a 3-day weekend, then spent 4 additional days familiarizing myself with the open book outline, reading roughly 50 pages of it per day. This was with a focus not really on mastering content, but on having a working knowledge of what material was covered in the outline and understanding where to locate the topics quickly. With that preparation, I encountered no difficulty passing the exam. And again, this is something I found to be typical from discussions with my peers. Others explained to me how they tabbed their outlines extensively or found an alternate table of contents online that listed subtopics in greater detail so they could use their outline more effectively. And even without doing those things, I found that it really was not terribly challenging. This was not an educational or professional experience I would really associate with genuine learning or skill development. Rather than being seen as an opportunity for deep engagement with New York law, I think the structure of the law course and law exam just encouraged strategic consumption of the outline for the sake of completion of a formal requirement. As it stands now, it's really just another box on the checklist to bar admission and not seen as an instructional tool, and it really seems to have little use as an evaluative one. since anyone who knows how to take an exam should be able to pass it without much difficulty. And I think anyone who's made it to the third year of law school is a good test taker. If the intended purpose was to ensure that new attorneys have acquired a working knowledge of New York specific law and are practice ready, the New York law exam didn't really accomplish that. Rather, it produced a small exposure to New York law that is quickly forgotten by most students as they move on to their next hurdle and get back to work on their classes. The second thing I wanted to discuss, student engagement with New York practice courses is minimal because, in my view, there's no formal requirement to take them. Personally, practicing in New York was always my intent. So in my third year of school, I enrolled in 2 upper-level classes focused on New York specific law, a 2-credit course called The Burden of Proof taught by Judge Philip Halpern at the SDNY, and a 4-credit course, New York Practice, focused on the CPLR taught by Anthony Santone. Enrollment was 12 and 15 students, respectively, well below their capacity. Burden of Proof, which I took in the fall of 2024, involved general litigation, best practices, and some CPLR instruction. And the judge made clear that in no uncertain terms that all of us must take a full CPLR course before graduating. But despite that directive, I was actually the only student from the Burden of Proof class who actually did enroll in New York Practice the following semester. Most students enrolled in New York Practice were part-time students, likely because the class was held on Saturday mornings. But also I think the part-time students who were mostly paralegals or investigators knew how important the material was, because in my observation, most full-time students really did not prioritize taking any New York law classes at all. There's no New York Trust and Estates class offered at Pace. An interest in engagement in New York criminal procedure class was also so low that it was offered only once a year in the fall semesters. Since you cannot practice unless you pass the bar, of course, it's only natural that students prioritize this, and the school definitely encourages taking as many bar classes as possible, so New York classes are left by the wayside. I was especially surprised that so few students were interested in taking Judge Halpern's class, given that it was such a valuable opportunity. So I really think more has to be done to try to prioritize that. If you look through the enrollment records, which I did of the spring 2025 semester, there's a clear pattern. Upper level courses that help with bar prep have the highest engagement. The 2 sections of a 3-credit MBE strategies class, which was essentially a multi-topic bar review course for third-year students, had a combined enrollment of 198 from a 216 student class, which obviously a drastic difference from the 15 for New York Practice. To me, the most effective solution would be making some form of New York law course or a practical clinic required for bar admission, similar to the requirements for an administrative law and a legal ethics credit. I enrolled in 2 classes that qualified for the administrative law requirement, labor law and administrative law. Both were at or near their capacity. Many of my classmates in these courses, particularly in labor law, admitted that they had no intention of entering the practice area and just needed the credit. So if the goal is to get students to take a New York practice class while they were in law school, mandating a New York law credit or giving some kind of dispensation for taking one would surely be effective. And my third point is on the topic of the open book versus closed book exam question. My perspective is that while I have a preference for open book exams, I think this is really a false choice because retention depends on use, not any particular examination format. I'll admit that I'm not a professional educator and have not conducted empirical research on testing methods, but I have taken many law school final exams in both open book and closed book formats. And in my personal experience, I have found that closed book exams, I've not found that closed book exams cause me to learn or retain material more effectively than open book exams. Both formats can be studied for intensively in the weeks leading up to the exam, and course material then forgotten a few months later once the exam is passed and attention shifts to other subjects. I also question the utility of closed book exams because the practice of law itself seems so rarely closed book, or at least it appears that way to someone who's not yet practiced. The situations where obscure, complex rules cannot be looked up if the lawyer knows where to find them seem to be limited. So I have to ask what skill a closed book exam is really testing. The decisive factor in whether legal knowledge is retained is not the format of the exam, but whether the knowledge is used repeatedly in future practice or coursework. The cliche, if you don't lose it, you use it, has definitely been my experience, regardless of the rigors of studying or how the exam was structured. So I do not see a strong pedagogical advantage to requiring any future New York specific licensing assessment to be some high stakes closed book exam that you cram for then forget. The best approach to building competency would be to require taking a full semester class or clinic in New York practice in the final year of study. Ideally one that has a practical component, such as drafting and filing simulated pleadings, motions, bills of particulars, that sort of thing, which I had to do in my New York practice class and thought was quite useful. This would definitely help the student engage with the material more deeply than they would with the current NYLE, or if it's added back to the bar exam during a 10-week marathon cram session, where New York practice is just one bar topic out of many. So those were the things that I wanted to talk about, and I'd welcome any questions. Thanks again.
You're muted, Ed.
I think.
Ed Carney, you're muted.
I'm sorry, I didn't hear you. I was just asking any questions, but I see that Judge Glenn has a question.
Yeah, I want to be very quick, but again, I'm quite interested. Thank you very much. I thought that was very enlightening. Given the fact that I guess many of us forget about how many foreign students or graduates of foreign law schools and graduates of law schools from other states take the New York bar, the idea that we're just going to require taking New York courses, New York practice or New York substantive law courses in law school, I think is unrealistic. So I'm wondering whether or how you feel about the position that was taken by the New York City Bar about a really well-developed, pedagogically sophisticated 20-week course in New York practice and the substantive law that so many people who will practice in New York need to know, and no test at all.
Well, I would certainly think that something like that is definitely better than a current system of just a very cursory test or having it be something that's part of the bar exam. And I also noted that I think during the first public hearing, there was a professor from Albany who mentioned that when he went to school in Boston, he did take a New York practice course when it was required. So definitely seems the case that people did take it when they had to. But yes, if the option is between a high stakes exam and a 20-week or a course that would actually help prep people for practice, I would definitely prefer the actual course. I think definitely taking a New York law class certainly engages you with the material much better than studying for an exam, which you'll just forget everything as soon as within a few months or within a year.
Thank you.
Thank you. Okay, our next speaker is Randall Tesser.
Sorry, Judge. Randy decided not to testify. I guess I thought I hadn't said that.
Okay, thank you. Okay, we have Judge Eileen Nadelson, founder of Judge for Yourself. Judge? You're on mute.
Oh, okay. I'm not a techie also, so I had to navigate. Thank you.
We appreciate your patience. Let me
Yes,
start.
very much. You really taxed my patience. Well, let me just start. Let me get myself composed, okay? I really appreciate the opportunity to give you my 2 cents worth of views for these.
And we're glad to have you.
And but now I understand why. I'll tell you what I do. I'm a judge retired from New York City. I now residing in Westchester County. You can see the trees behind me. I'm actually in the country now. And what I decided is that I was not going to retire in 2015. So yes, I am that old. And when in 2015 I decided I'm not going to retire, and I decided to do counseling and mentoring for colleagues to make them better advocates. And I've been doing that on a daily basis. I'm actually in the trenches with my clients, the counsel. And I now understand, and by the way, just let me clarify that, they are not just beginners, like some of the newcomers here. They are seasoned attorneys, 10 years and plus. So I could tell you, I know why the system doesn't work now, because I'm in the trenches with them and hearing what's been going on here with what's going on with the testing. Now I know why they don't know what they're doing, because these are all people, a lot of them coming out in the last 10 years. So I just I'm going to focus on, because I am the one on focus. When I sat on the bench, it was counsel, focus. I do not have the patience for you to go on and on as I'm doing right now. All right. So I'm going to focus on the first issue, which is the relative importance of having a New York law specific component to the bar exam, my immediate reaction to that is yes, you need a New York relative component in the bar exam. If you're going to go to a New York law school and you're going to reside in New York, or even if you're not, but if you're temporarily residing in New York, and chances are that you're going to be practicing in New York, then you need to know how to practice under New York law. That's a no-brainer for me. I don't know why we even consider it a possibility. It's not even a possibility in my book. It's not an afterthought. This is not an afterthought. If you're going to be in New York, then you need to know New York practice. And that's what's required. And the fact that there are law students that come here from other countries, it's required on our tests. Let me tell you something, even if you live in Idaho or Indiana and you're not going to practice in New York, as my father would say, no education is wasted. It broadens your perspective. So you may not think you need it now, but you may need it in the future. All right. So sometime when you're living in Idaho, you may have a case in New York, and you'll be very glad that you know about New York practice. It's part of becoming a lawyer. We are lawyers. We're supposed to be trained for the public. I also have something to say about the fact that our bar exam is not for the student. It's not for the student. I took the bar exam, okay? I know. It wasn't for my benefit. You're talking as if we have to make it easy for the student to take a bar exam. It's for the public. We serve the public. And it's our job to make sure that the clientele that we service is having the right kind of representation in order to give them the right form of justice. We're the form of justice. May I have to repeat that to the lawyers that are in this room with me? I mean, really. Okay, so concentrate on the fact that you need to train our students so that they are really competent, capable, and knowledgeable lawyers, so that the public is actually getting the benefit of the student, not the other way around. And when it comes to law school, all right, we're so concerned about how the law school is going to fit it into their curriculum. We don't tell the law schools how to fit it into their curriculum. They figure it out. Law schools, that's their job, to figure out how to fit it into their curriculum. We need them to come out competent and capable. They need to train them to come out competent and capable. If they need to teach them New York law, then they teach them New York law. What is there to know about that? I mean, we make this sound like we're puppets here. We're not puppets. We're lawyers. When I work with my clients, I consistently remind them about being a lawyer. You're a lawyer. That means your job is to do service to your client. You need to have everything in your arsenal in order to do a complete and proper job as a lawyer. And that means teach our students how to come out fully capable. And yes, do we forget things? Yes, we do forget things. It comes back. Once it's in your medulla, as they say, it stays in your brain. Once you have that information, you know where to go to get it again. And we have CLE requirements so that maybe once in a while you refresh it, you upgrade it or update it. It's not like you have to remember it every single day of your life. And maybe you won't do some particular aspects of law. So at least you know what it is. Like I was listening to the Trusted Estates people. I didn't know that they don't even give it on the exam. When I took the exam, and I did it before 2016, when it seemed to have turned around into a debacle. I took it before that. I had to study everything. I mean, everything. Everything was on the test, including New York law. And I made it through. First time, I'm proud to say that. First time I made it through. And it was very daunting. And let me tell you something. There's no mistake that the rest of we are considered the benchmark. New York lawyers are considered the benchmark of legal practice. I mean, we're the hub of complex cases and upscale business dealings. I mean, and let's face it, New York law can be quite daunting and very complicated. If you can't maneuver and analyze and strategize and negotiate inside the courthouse and the conference room, then you're not ready to be a lawyer. And if you fail the test, you're supposed to fail the test because you're not ready to be a lawyer. And so take it again. What is the big deal here, folks? I want people coming out of school ready. And when you get out of school, let me do the thing on, I know I'm ranting and raving now because I'm passionate about this. I'm passionate about what we're supposed to do as lawyers in the world. We're lawyers. We have to service the public. That's our job. Okay. And so when you come out of school, I want the student ready to hit the ground running, You know, that's when you put whatever you learned in your course structure. Now you're putting it to the test. Now you're putting it into practice. Now you're seeing how it works there in the real world. You're not supposed to be going on to another course, another school. We're going to send you out to another school to learn what you should have learned in the law school. It's not an afterthought. New York practice is not an afterthought. It is an integral part of how you practice law in this state. And if you don't practice law in the state, then you don't have to worry about it when you leave the state. But when you're on the state, you should know how to practice law, New York law, in this state. And I don't even know why we're even considering any other option. And as far as having, okay, an open or closed test, I'm getting right to the point here with you. I don't really care if it's open or closed, but I got to tell you that if you are not studying and not prepared to face the questions for New York law, at the time, I don't think having an open book is really going to be much value to you. There's no way to wing a test. You either are prepared or you're not prepared. Okay, so anybody who comes thinking they're going to wing the test, it's a fool's errand. You'll find out that it's not going to be successful. So my perspective here, closing it around, is that yes, to the point, it is relatively important that we do have a law-specific component in our bar exam. Yes, we should have it written down. Yes, to tell you the truth, a lot of people don't know how to write anymore. They need the computer because they can't even sign their names. I have clients who cannot sign their names. Do you believe that? They come out of school, they've never had penmanship. They only know how to type it. It's all finger pudding now, folks. There's no mental stuff going on. And we're lawyers. We're everything else and mental structure. There is nothing else for the lawyer is required. We are the mental structure. If you can't think, then you're in the wrong profession. Don't even think about it. And it's not making it easy for you. I'm not making it easy for you. If you came up before me at court, yes, I do. The first beginner, I want you being just as prepared as the 30-year-old practitioner. That's exactly, somebody said that, and I nodded my head. Absolutely correct. Do not come before the judge or do not come into the conference room unless you're ready to be a lawyer. And if you're not ready to be a lawyer, then don't be a lawyer. That's my attitude about this, and I am destined. I am out here to make sure, this is my passion, my mission in life, that when I got off the bench, I was going to counsel and mentor lawyers. And so I started this new counseling Judge for Yourself, and that's what I do. And I love it. It really satisfies me, and it shows me that I am needed out there, which is a nice thing to do. I'm needed out there because let me tell you, they're not thinking the way they should be thinking. And that is a very serious problem. If you have a lawyer that doesn't think like a lawyer, you have a serious problem in the society. Serious problem. I don't need to say any more than that. I think I've brought it to a close. And I just want to thank you for your time and your listening to this tirade. But that's where I stand. Don't even think about it any further. We need people prepared to be lawyers. We're not sending out students to be lawyers. That's the end of my song.
Thank you. Thank you. Are there any questions? Okay, again, we appreciate your attendance and your patience. Thanks so much.
You're welcome.
And let's see, next we have Professor Kaufman from Touro University. Professor?
Hi. Thank you so much for the opportunity to address you today. And thank you also for undertaking this really serious inquiry into how best to ensure the competency of lawyers to practice in this state. There's obviously a lot of passion out there that you've heard today, but it is an awfully serious issue. As I thought about my testimony for today, I realized that I've been in the trenches on this issue for more than a quarter of a century. I had the privilege to serve as co-chair with Judge Glenn of the New York State Bar Association Committee on Legal Education and Admission to the Bar. And I've chaired, I've been a member of a host of city, state, national committees and task forces on education and licensing. Since 2000, I've been a member of the Collaboratory on Legal Education and Licensing for Practice. And I know you've heard from one of our members, Deborah Merritt, who I think addressed this committee a while ago. I also participated in the groundbreaking study, Building a Better Bar, that's now pretty universally recognized as identifying the core competencies of practice. And I'm happy to note that in all of this time, there's been such a change in conventional wisdom and thinking about how best to license lawyers. And I'll just note three important ways that I think the thinking has fundamentally changed, although it may be not universally acknowledged given some of the comments before you today, but I think most people do agree that a test that focuses on memorizing hundreds and hundreds of detailed rules is not the way to assess competence to practice law. Indeed, even the NCBE that insisted for decades that that was the way to test no longer believes that and will not be, what they say, it will not be requiring that kind of memorization on NextGen. Second, we also now know so much more about what we mean when we talk about competency to practice law. Thanks to a number of studies, one done by the NCBE, but a fabulous study called Building a Better Bar, which laid out the 12 building blocks of minimum competence. And third, we know so much more about how adult students learn about what really makes knowledge stick. Now, I understand that this committee's charge is to determine whether there should be a New York component to the bar exam, and if so, what it should look like, and whether the current New York law course and New York law exam should be modified in some way. I've listened to all of the testimony, both today and in your previous two hearings, and I fully agree with those who have urged this committee to adopt an approach whose goal is not to sort candidates, rely on NextGen for that, but whose goal is instead to ensure that candidates actually learn New York law in a meaningful way. And to me, that means through interactive courses, either delivered through law schools or through a beefed up CLE. For the New York component, we need to shift from focusing on how we test or even how we teach to how students learn. And the literature all suggests that students learn and the knowledge sticks when they use it and apply the rules. And I think instinctively, we all know that. I used to teach evidence and I could teach how to introduce something into evidence, but until you've stood in court and actually done it, you don't know. It's using the rules that makes that knowledge your own. We all, I think, instinctively understand that because we've all experienced that. But I'm actually here today to ask this committee to move the needle a little further. And thank you for allowing me to do that today, because I know it's off your specific charge just a little bit. What I'm asking this committee to do is to suggest to the New York Court of Appeals that they appoint a working group. So maybe this will not be your task, but a working group of some sort to develop a limited pilot project of the Lawyers Justice Corps, a pathway to licensure that would serve two compelling goals. It would provide a better measure of lawyer competence by evaluating actual performance, and it would continue New York's long and proud history of working to eliminate the justice gap and enhance access to justice. So my written submission describes the Lawyers Justice Corps. I'll just very quickly summarize it in just a minute or two. It is a supervised practice model. It would be open to law graduates who are hired by legal services providers. And New York already knows who those providers are. We have a list of approved legal services providers that the New York Court of Appeals compiled for purposes of the Pro Bono Scholars Program. So that work is already done. When I say it would be open to law graduates hired by legal services providers using their own hiring techniques, we're not asking them to change anything. The participants would be paid the ordinary entry-level salary that these programs pay. Participants would have to make a one-year commitment to work for those programs. How long that commitment is, I think people can reasonably disagree on that. I personally would like it to be a longer commitment. Others have persuaded me it should be 1 year. It's one of many things that would have to be determined. And an important part of this program is the rigorous training and supervision and the utilization of rubrics and assessments that reflect the building a better bar building blocks of competence. I should add that this work has already been done. It's being used right now in Oregon. So it doesn't mean starting all over again. And participants would be licensed after 6 months of this work based on an outsider's evaluation of their portfolio of work. And as I said, I think the Lawyers Justice Corps has two critical benefits. One, it enhances access to justice. Two, it's a better way of measuring competence. And I'll say just a couple of words about each, and then I'll be done. How does it enhance access to justice? Well, we conceive of the Lawyers Justice Corps as creating a cadre of public interest lawyers, lawyers committed to working for legal services programs. And those people still exist. I went to law school in 1972 for the sole purpose of being a legal services lawyer. And there are, law school does a lot to drum that out of their students, but there are still so many students that chose the law because that's the work they want to do. And they would be put to work representing the indigent immediately upon graduation from law school. Assuming a pilot project of, just for argument's sake, 100 participants, the 500 hours that students currently spend on studying for the bar exam would translate into 50,000 hours of client work, direct client work. So it would help to address the justice gap and what's increasingly being called the legal desert that exists in so many places, particularly in rural areas. I should say I've met with legal services providers around this state to get their insights into whether this is workable and whether it would impose unacceptable burdens on them. And I'm happy to report their enthusiasm for the concept and their belief that this could make a meaningful dent in their ability to serve their clients. And as to the second benefit, how is it a better bar exam? Well, it's a true performance test, and we all know that's the gold standard of assessment. It's assessment based on actual lawyering performance, not ability to answer multiple choice questions. It's linked to the competencies identified as essential to the practice of law. And let me conclude by pointing out that there's empirical data that supports the Lawyers Justice Corps as a pathway for licensing. I co-authored an article with Professor Merritt and with Professor Andy Curcio, in which we analyzed data from California's provisional licensing program. And that analysis demonstrates that a supervisory practice program increases the diversity of the practice teams within the organization. Indeed, a full 93% of public interest supervisors cited that benefit. The data also shows that the supervisors did a marvelous job of providing supervision and training. the model allows states to assess a broader range of lawyering skills and doctrinal knowledge that can be assessed on a 2-day test. And the program allowed public interest organizations to serve more clients. So in short, the data supports the claim that a lawyer's justice corps would serve as a better and more rigorous licensing pathway, and it would enhance access to justice and promote diversity within the profession. And central to this committee's central task, since graduates in a lawyer's justice corps would be practicing New York law, it addresses the question you're grappling with: how to ensure that graduates licensed to practice in New York actually know New York law. So I know I've taken you a little afield from your specific charge, but I think I really haven't, because you're trying to ensure that candidates admitted to the bar in New York know New York law. And I think the time is ripe to explore a pathway that accomplishes just that, because it's consciously structured to do that, to create practice-ready knowledge of New York law. So thank you for this opportunity to talk to you. And of course, I'd be happy to answer your questions.
Thank you, Professor. Sherry, did you have a question for the professor?
Yes, I do. Thank you, Professor, and thank you for taking the time and the patience of waiting such a long time to share your thoughts with us. I'm a legal services attorney. I'm a deputy executive director of a legal aid organization. And while certainly I think the idea of clinical programming is beneficial, and I'm somebody who's been trying to come up with creative ways to assist some schools in expanding their clinical opportunities. I pause and have concern with this idea that we would be, or in essence, or the court would be in essence, mandating that legal services organizations hire somebody for a year on a lawyer's first year salary, only for that year. So it's twofold. One, because that comes out of the budget, and part of when we hire new lawyers, we want to know that we hope they're going to stay. We're putting a lot of effort into training them and a lot of effort into, creating them as members of the team. And while we have interns and law students all the time, pro bono scholars, and that's great, and we have people come for the summer, we're not required to pay a first year salary to anybody, because of a clinical program or that type of thing. And that's a lot, I think, to ask of the legal services organizations, and certainly to put out there as kind of, this would be the requirement and you have to join in on it without some kind of funding behind it, right? So I think it's one of those, it would become, in my concern is it would become an unfunded mandate in essence, which we shy away from, as you know. And so I just am curious about, because I don't know much about Oregon's program, but I'm curious how they handle that aspect of it. And while I agree, yes, we want to create more legal services lawyers and bring them into the fold and have them choose that pathway, I'm just concerned about the type of mandate that it would, in essence, create. And so I'm wondering, is there some kind of funding alternative, or do the law schools help with it? I mean, how does that work?
I so appreciate that question, because, as I said, one reason I made a point of talking to as many legal services providers as I did was because I didn't want to propose a program that just imposed more burdens on organizations that are already under-resourced and spread too thin. But first of all, there's no mandate. No program has to take these students. And it's not paying a salary for a clinical program. These are hires. Legal services offices would hire graduates in the same way they currently do, in exactly the same way they currently do. And they pay the people they hire an entry-level salary. So nothing changes with that. As to whether it would cost them more, the cost that I see are the time in evaluating the work product and in ensuring appropriate and tight supervision and training. So in terms of funding, if I'm right that might increase the cost somewhat, I think I have two answers to that. One, students pay a fee to take the bar exam, so they could pay a fee to participate in this program, and that could offset the costs. And secondly, when I've been talking about this proposal for a very long time and went to some funders about, because I think there are organizations out there that would provide some funding. But it was a catch-22 because they wanted to know which state had signed on to this. And, so what do you do first? It's hard to get the state to sign on without that funding commitment in some cases. But the funders want to know that this isn't something theoretical, that there's a state ready to do this if they provide some funding. So I think there are opportunities for funding out there. I don't think we need many resources, though. I don't think we need much funding because as far as developing the rubrics, that's already been done. As I said, Professor Merritt has, she's amazing in what she's produced. And to the extent that I know John McAlery is on the call, so he'll correct me if I'm wrong, but I think that graders for the bar exam are paid a certain amount per exam. So one thing that would have to happen is we anticipate that outside evaluators would assess the portfolio. We don't want the supervisor doing it because, the supervisor doesn't want to have the future of their employee in their hands. So we anticipate having to hire outside evaluators. It could be members of the Board of Bar Exam. It could be others who I think would have more interest in evaluating these portfolios than the bar exam questions like the.
But do you mean outside, I'm sorry, but do you mean outside evaluators to evaluate the work that the students are doing for the legal services organizations?
They would, what Oregon does, by the way, Oregon is a general supervised practice program. It's not limited to, it has nothing to do with access to justice because they'll work in any law office. And they would be required to put together a portfolio of work. And there are detailed rules about what qualifies, what kind of work has to be in the portfolio. And the outside evaluator is evaluating those written submissions. The supervisor, of course, is on a day-to-day basis doing the supervision, but the outside evaluator is the one who assesses the portfolio of work.
And there's no concern about confidentiality?
Oh, yes. Oh, there are detailed rules about that, about ensuring confidentiality and redacting names. Absolutely.
Okay, thank you. Any other questions for the professor? We appreciate your time and your patience. Thank you.
Thank you very much.
Okay, last, we're going to hear from the New York State Board of Law Examiners, Brian Williams, board member, and John McAlery, executive director.
All right. Well, good afternoon, everyone.
Yes, good afternoon, and thank you. Welcome. And again, thank you for your patience here today.
That's quite all right. That's quite all right. I'd like to first thank the advisory committee, the co-chairs, the Honorable Edward Carney and Sherry Lynn Levin Wallace, and the members of the committee for giving the board the opportunity to address the question today, to what extent, what options should we have as far as the pre or post admission requirements for the next gen bar? My name's Brian Williams, and I'm a member of the New York State Board of Law Examiners. I have been a member of the board since 1996. Before I was a member of the board, I was an assistant to a board member, the Honorable Lord Taylor Swain, and in that capacity and in the capacity as a board member up until 2015, I wrote and both essays and short answer questions for the bar exam and also graded the bar exam. I have been practicing commercial litigation in New York State for about 44 years. I'm still an active litigator in the state courts of New York and in the federal courts of New York. And I'm here today on behalf of the board to really address the issue about this New York component to the bar exam. In short, our board believes that the best option as far as a component for the New York part of the bar exam is the component that we have now, our current component. Because the next gen bar exam serves as the test of competency. It's a validated test. And so we don't believe there's a need for any additional high stakes test to test New York law. I want to go through not only exactly what the New York exam is, but also talk about some of the criticisms and what we think are ways to address that. And I just want to be clear, we have a written submission. I'm sure all of you have already read it. But our New York component as it stands now is really made up of three things. We have videos, which are about 18 hours worth of videos, course materials, which are about 207 pages of free course materials, and then the New York exam itself, New York law exam itself. And in us getting to this, the first thing we have to address, and it's the thing you always have to address when you're looking at the New York bar, is the number of applicants that we have. In 2024, the board examined about 14,000, in excess of 14,000 candidates. They came from 49 states, the District of Columbia, Puerto Rico, and about 189 law schools, in addition to about 123 foreign countries. Now, 37% of those graduates came from New York law schools, about 26% of those graduates from out-of-state law schools, and another 37% were foreign educated, which means they got a law degree from a foreign common law country or got an LLM. And therefore, 63% of the applicants that we're talking about we test in New York do not obtain a JD degree from either a New York law school, and they don't have the opportunity to take a New York course curriculum during law school. So when we're talking about how we have to approach this, we have to look at the fact that 63% of the people taking the exam don't necessarily go to a New York law school and aren't necessarily in a position to take New York specific courses in law school. Now, our current system, we have a combination of the 2-day UBE, which is the bar exam. Then we have the New York law course, and then the New York examination. Now, the course is an online course, and it tests important and unique principles of New York law. And it tests matrimonial and family law, professional administrative law, business relationships, civil procedure, conflict of laws, contracts, criminal law and procedure, evidence, real property, torts and tort damages, and trust, wills, and estates. And we have these videos, which are lectures given by professors from law schools, judges, and practicing attorneys. You must complete all of the law course videos before an applicant can then register for the New York law exam. And the candidates must view each lecture in its entirety at its normal speed. Advancing or speeding up the video by any means is prohibited. The New York law exam is a 50-item, 2-hour open book multiple choice test administered 3 times a year. And I just talked about the different subject areas that appear on that test. And we support that test as what we should be using to test New York law when we are using, at this point, the UBE and going forward next gen. Now, we know there are a lot of criticisms to this New York law exam. One of them is the idea that it's too easy. And there's even the testimony today about that. But when we look at the statistics between 2022 and 2025, the overall passing rate for this open book exam was 79%, which means 21% of people who took the exam did not pass the exam. And that's an open book exam. What we believe these statistics illustrates is that the New York law exam is a sufficiently rigorous exam when you pair it with the mandated viewing of the law course, which consists of the 18 lectures, and the written course materials, which are 207 pages in length, which are available free to candidates, and then they can keep that material for later. The open book nature of the exam actually complements the rigor to the exam. To answer the problem-solving questions, a test taker needs to review the appropriate chapter in the course materials, addressing the area of law to locate the precise information, then apply it to the fact scenarios and questions, and then correctly select the right answer. We maintain that this is not just an easy test, and I think that the fact that 20% of the people who take it and don't pass it is evidence of that. The candidates are permitted to have access to their course materials and their own notes during the New York law exam. The order of the questions are scrambled so that candidates receive questions in different orders. They can't do any backwards navigation. So once a candidate has navigated to the next question, they can't return to a prior question. Therefore, if a group of candidates take the exam together, they cannot help each other because the questions come differently. The course materials posted on the board's website are not text searchable, and electronically searching the course materials while taking the NYLE is prohibited. Now, the passing score now is 60%, 30 out of 50. If you fail the New York law exam, then you have to take the course over as well as the exam over. We want to make sure that it's understood that the New York law exam is intended as a motivation for candidates to pay attention to the law course and to thoroughly review the course materials as a continuation of the learning process. But it's not intended to be a high-stakes exam, never was. There's been some testimony about, well, there was a prior exam, the way it was before 2015, when you had a New York-specific part of the exam, and that then people really concentrated on New York law. The way the prior exam worked was that 50% of the exam was the MBE, and 10% was the MPT, then 30% were 5 New York essays, and 50 multiple choice questions that were short answer questions were 10%. These questions all combine general principles of law with New York specific rules. So it wasn't that with the essay questions, they were just specifically New York related subjects. The authorities for the essays were always coming from New York cases, but they weren't just New York principles. They were principles of law, which may apply in New York. So consequently, a candidate who had no knowledge of New York specific law, but who had adequate knowledge of general principles of law, could apply those principles and receive credit for their answers. And so really, we take the position that having these courses and having the outlines that are New York specific will give our candidates the information about New York law that is very specific now, just as much as when we had the old exam before the UBE. Now, again, we don't want to look at having a second high stakes exam, but clearly there are things that could be done to the New York law exam to change it. If there's a feeling that there's not enough procedure on the exam could be increased in time, so there'll be more procedure, or we could just have a mandate to have more questions on the CPLR on the exam. And then the non-civil procedure portion would then test just the New York distinctions in the other substantive law areas. We could consider raising the passing score on the exam because 60%, it could be considered a low bar on an open book exam. And that could be one of the things that could happen. If the concern is security, we could look at going to testing centers to give the New York law exam similar to the MPRE, although that could create some issues with respect to cost and having to draft numerous questions, so there would be a fresh bank of questions in that kind of model. What we don't think we should have is a second day local component that builds off the next gen bar exam. What that would do would be to make it so we would just have more hurdles for candidates to be able to pass the bar exam and to gain admission into New York. There would be issues, we believe, with how score transfer applicants would take the local component if they had taken the bar exam in a different state, and now they have to take the local component in New York, then they wouldn't be here on that day to take it, and therefore we'd have to create another opportunity for them to take it, which is more cost, more places. And the reason we would not want more people coming on that one day, that second day, that would then add to the number of people who take the bar exam, which is already 14,000 in for a year in New York, and that would just add to it. So if you were taking the exam that right now you can take it in another state, waive your score in. If you had to be in New York to take it on that day, that adds to our costs. And then the possibility that there would be an unfair advantage to people who have to prepare for both the UBE or the next gen and the New York law exam at the same time compared to folks who took it on different days. Again, in conclusion, we don't believe that there's a need to spend tens of thousands of dollars on psychometricians to develop a separate New York exam. The current UBE and the next gen, they were professionally developed. I think you've heard a lot of people have a lot of confidence in their psychometricians and what NCB does. We don't think that there's a need to replicate that. We don't mean for the New York law exam to be a vehicle. We don't mean for it to be another high stakes exam. It's simply a vehicle to educate candidates about the nuances of New York law. And that's why it doesn't need to be professionally validated, but we think it serves the purpose that it needs to serve with respect to having the next gen as our bar exam, and in looking at the numbers of people who are taking the bar exam in New York, we think it's an adequate way to test those parts of New York law that are important in the way that we do it, so people will know the law and not in a high stakes test type of situation. And I'll take any questions, or John will take any questions.
Okay, thank you. Are there any questions? Okay. Thank you so much. Brian,
Judge Carney, it's John McElary. If I can, I'll be very brief because I know it's been a long day for all of you. And thank you for the work that you're doing. I know I've had the opportunity to speak with you previously offline and not with not as a public hearing. I just wanted to briefly emphasize a couple of things that Brian Williams had mentioned. You know, I listened. This has been great listening to this. It's been wonderful. A lot of great ideas and thoughts, and I appreciate every single person who has testified here today and during your prior two hearings. One of the things I do just want to that bugged me a bit, I'll say, is the thought and the testimony you've heard that the next gen bar exam is not going to test writing. That is just absolutely not true, and I can't be more adamant about that. You know, is it teaching it differently? Yes. There are three what's called performance test items. They're a bit shorter than the current ones. On the bar exam now, there are two what's called MPT, multi-state performance tests. On the next gen, there'll be three of them. Each of them are designed as 60-minute items. But what these are things that are, you know, you're asking them to be the applicants to be practical writings. You may have to write a letter to a client, write a memo to a partner on these things. And these are more practical things that you would expect a new lawyer to do than just trying to write an essay and, you know, throw in everything they know about contracts. So we think this is going to be a better way to write. Yes, there are some shorter, you know, written components. Our board has looked at this. We've had a number of presentations with NCBE. We're satisfied that the next gen bar exam is going to adequately test writing. So whatever, you know, if we continue to do some kind of New York component, I would focus on the things that you think that the next gen is missing. I don't think you need to have essay writing on any local component. If you're talking about a 3-hour test on the afternoon, the second day, that's not a lot of time. I think if you want to, if the thought is to test New York law, I mean, frankly, the best way to broadly and deeply test any subject is going to be multiple choice questions, and it will be graded much faster. You add essays to it, it's going to add time to grading the bar examination. So I know Brian mentioned already about, you know, our board's position is we don't want to put it on the second day of, if there is going to be a local component, not to put it in person on the second day. I know David Marshall spoke about, well, that would be a fair thing to do. Well, you know, in some respects, yes, but the unfair thing is, what do you do about all the transfers? And we had 1,200 people transfer scores into New York last year alone. What happens with those folks? We would have to have another day or two exams for them, one or two more exams to do it. And they would just be coming in testing only on New York law, as opposed to the people in February and July who have to learn both exams at the same time. You know, I think psychometricians would question the reliability and validity of that type of mechanism as an admission requirement. So I think our point is we just want to raise these issues, and just so you are aware of that on it. Again, if, you know, there's a few, I won't, you know, belabor this. I mean, if there's any other questions that you may have for us, we're certainly available to come back, talk to you, answer questions in writing.
Okay, thanks, John.
Thank you for the opportunity.
You had your hand up there, and I don't know if the question was for John or for Brian, but
well, probably for both. So thank you both. Thank you, Brian, and thank you, John, for your testimony today. Thank you for your patience. Thank you, John. You've made yourself available in the past, and we appreciate that. My question is in part about the approach that's being taken in Ohio. And I don't know, John, whether you're aware of what's going on in Ohio or what recommendations have been made, or Brian, I know you follow the bar world pretty closely. So in Ohio, like in New York, there was an advisory committee put together. They were asked a little broader question. They were asked, should we adopt the next gen? Should we not? And if we do, what else should we do? And they recommended, the advisory committee issued a report, and they recommended adopting the next gen. And then they looked at the question of should we stick with what we do now in Ohio or should we do something else? And what they do now in Ohio basically is 25 multiple choice questions, and it's open book, and it's all online. And it basically sounds a little bit like what we've been trying to do in New York, which is sort of focus on the unique aspects of the judicial system as well as state-specific laws to make sure candidates have some familiarity. And the advisory committee, concluded that they wanted something more than that. They thought a more substantive exam would be called for, and their recommendation was for the court to go back to the Board of Law Examiners, calling for a more substantive exam, but leaving it to the Board of Law Examiners exactly how to frame that, working with psychometricians, working with test developers, consider the possibility of essays. They didn't mandate any particular format. They didn't mandate any particular timing. You have to do it on the afternoon of the exam. You have to do it this way or that way. But they were concerned about trust in the states not being part of the next gen exam. They are concerned, and John, I hear you, and there's been sort of conflicting testimony on this about essay questions, but they were concerned in their recommendations about that. And again, they weren't saying you have to do it this way. But I wonder about that. I mean, you've both talked about, well, you talked about, Brian, today, and in your report you talked about we could make the exam more rigorous. We could raise the passing score. We could do different things. I wonder whether, in your view, what's going on in Ohio would make any sense in New York. If we could recommend, would it be feasible to recommend to the court that a more substantive exam be prepared, but that be in your hands as to format, et cetera, working with test developers and psychometricians?
Michael, I guess, you can ask 10 different people what substantive means and get 10 different answers. So if that was a recommendation to come back to the board to do a more substantive exam, I think it should come with some more ideas as to what we mean by substantive, We mentioned a few things. We could raise the cut score on this test. It's a 30 out of 50, that's a 60. Raise it to 35, that's a 70. But does that make it a more rigorous exam? I guess it just makes it a more harder exam. We've heard testimony from some of these young lawyers. I mean, we heard one once before that kind of like the New York law course and New York law exam. When I've spoken with students, I run the gamut. I get some that thought it was really good. Oh my gosh, I learned stuff in contracts and torts that I never learned in law school, which is incredulous. Others who feel it's a waste of time. I think as far as to me, I think if you were going to do, if the bar exam, the next gen bar exam is the validated, reliable exam. I know David Marshall talked about those terms a lot. There was an article written. I read those articles. I didn't disagree with the psychometrician. But some of that's comparing the local component to the bar exam. They're very different. So I don't think you need these two high stakes examinations on it. And even if you did a high stakes New York exam, my personal opinion, I've been at this for over 25 years. I've been a member of David's committee years ago, many years before, back when Judge Glenn was a chair of that committee, met with that committee. Some of these issues have been talked about for 25 years. If you make it more substantive exam, you're not going to get the law schools to suddenly have courses on New York law. I'm telling you, it's not going to happen. We heard it from the deans at your last hearing. They're not going to do that. I mean, law school is very different nowadays. Every law school in New York State, every law school in the country are competing nationally for students. So they're not going to change their curriculum when they've got students that are staying in New York. Some are going to New Jersey, some are going elsewhere on it. I don't think that it's, I think that the time of having New York law courses in law schools, I think that ship has sailed. And it started sailing long before the UBE, by the way. I mean, we've heard of, I know David Marshall talked about, some studies they did the last 10 years that the number of people taking New York practice and procedure have gone down. I don't doubt that, but I also saw numbers from that same committee that showed those numbers going down long before 2015. So there's been this steady decline in that, and yeah, is that a problem? Yes. So, I guess as far as, we probably would want to know, more about what you mean by a substantive exam. I mean, as I mentioned, you can raise the cut score, you can move it to a testing center where it's not an open book exam anymore. I guess that in one sense is more rigorous because you just can't look things up, but then we're getting back to memorizing. I've learned a lot about, in recent years and certainly through these committees, I'm intrigued by some of these studies now that are showing, humans just don't retain that information for that long. We had the young lawyer earlier talking about, okay, I took the New York Law course, the NYLE, and then I just forget it, it doesn't get retained. Well, that's the same argument about the current bar exam and the old bar exam. So I just think we need to be careful about what we're saying as what is a substantive exam. And I do think if we're going to talk about just a 2 to 3 hour test, my personal view is I wouldn't waste that time with essays because you just can't test as much knowledge with those essays on it. And let me give you a perfect example. Brian referred to the old bar exam. Back in 1992, 95, when they did this Millman report, there's no question. I read that report many years ago. It validated the exam as reliable. It did not validate the individual essay questions. I mean, those essay questions were never pre-tested, and pre-tested means, NCB does that every question on their exam now gets pre-tested. So you have a small groups prior to administering that test to see how it performs. We'd have to do something like that if we were going to do essay testing. The other thing about that old exam, you could pass it, and many did without knowing any New York law, because as Brian indicated, 2/3 of the people didn't go to a New York law school. Yes, some of them did LLMs at New York schools, but they're not taking, for the most part, they're not taking US law and New York law during those LLMs. So many of people could take that test, answer it under the general principles of the law that they taught, that they learned, which, I like to call the law of everywhere, basic principles that every law student should know. So, I'm sorry if I hope I answered your question there, Michael.
No, you did it. And I take your point, John, about the use of the word substantive. I think what we're trying to straddle is sort of there's a chasm here between having some awareness of New York differences and actually knowing something about New York law. And part of the challenge is that what we're hearing from a lot of different quarters, from judges, from academics, is that the law students who are coming out, they don't know New York law, and it's a problem. So it's a question of how do we deal with that?
I hear you. And to me, I've heard the same thing 15, 20, 25 years ago, from my participation in the New York State Bar Association's local committee there, because we had many of people who had taken the exam, as I mentioned, 2/3 who didn't go to a New York law school, didn't get a JD in New York law. They didn't learn any New York law at all on it. I suppose maybe they learned some from the bar review, so we have them pay an additional few $1,000s. There's equities to that, that we have to deal with. It's an issue, and I get it. What's the best way to do it? I am very intrigued by, our board has not taken a position on an interactive course. The first that we're hearing about it was through these public hearings. I am personally intrigued by that. I'd like to learn more about it. I don't know, I have questions about how it would work. I'm not aware of any state in the country that's doing something like that. If it's being done in other professions, maybe it'd be, nice to be able to see what that looks like. And whether there's some kind of assessment that's with it, so we know that they're paying attention on it. Because we know that on the New York law course, we get some folks aren't paying attention. Some of them speed up the videos. Every time we have a New York law exam, we have to, small numbers, by the way, we have to go and bring charges against people because they just sped up the courses and didn't bother to watch them. So, we've been policing that for years. So I do know in any kind of interactive course, you're going to have some sort of measurement to make sure they're paying attention and learning something. So, again, as I said, I don't know a lot about that. I know you had some testimony from Professor Debbie Merritt at an earlier date. She was kind enough to share her slides with me. Again, right now we haven't taken a position on it as a board, but I am certainly personally intrigued by that stuff.
Thanks, Jen. Judge Glenn, did you have a question?
Yeah, I guess it was sort of answered by that, because Going back to the original purpose of the committee, which is should there be a New York component to admission to the bar, which does not necessarily mean a test. I'm quite interested in again the New York City bars and Deborah Merritt's position, which might or might not include a test after. But I wondered how you feel about. I don't know whether it's a study. I don't know whether it's asking for further examination or whatever, but of the capacity of either the bar prep people or the bar prep people with a panel of New York experts to create a real law course, which would take the burden off of you to keep getting these 17, sort of every year and updating and so forth. And that could really be, that could bring to bear what I understand to be all of the new techniques that, post-COVID and whatever have come out of online learning and engaging people in that course. And whether that's something that you all would be interested in looking at, which would take some of the burden actually of creating the New York law course away from you, but also might ensure something that's more meaningful from a pedagogical standpoint, and that would really involve people learning about New York law and New York practice, as opposed to, essentially what sort of a bar prep about the differences. So I just wondered what your thoughts were, and I know that you've looked at Deborah's slide, so.
Brian, do you want to take a stab?
Well, no, just as a board, Judge Glenn, we haven't really looked at this, and what we learned today from the City Bar report was something brand new. I think we probably are willing to look at just a variety of things that would make sense for, again, the number of people that we would be involved, and making sense with the numbers and making sense as far as it being available or accessible to all of those numbers of people. But it's not something we've looked at this point.
Yeah, we did some looking back in 2015. Now, mindful, it was on May 1st, 2015, on Law Day, that the Judge Lippman announced that we were going to go to the UBE bar exam, and on the way out of the courthouse, he pats me on the back and says, "Now, good luck, John, getting a local component together in basically less than a year." We are a state agency. We would have to put out bids to get vendors. At that time, we started calling it. Would there people trying to learn about what would go into a bid, what the cost would be, and we realized, gosh, this is going to just be very expensive. So, and I think it might have been David Marshall commented, we're not educators here at the board. We did go down the road of developing that course internally. One of the reasons being is part of our charges was not to make it, excessively more expensive for these applicants. So the New York law course was free. We wrote to the state bar, we wrote to judges in the courts, to the law schools. We got a lot of volunteers to video record. That was a time-consuming task. And should they be updated more frequently? I wish they could. It's just, we don't have the bandwidth to constantly update them. Some of them have been updated over the years. We had to find, we found a videographer in one of the New York State agencies that had a studio, recorded them, and then afterwards, because you're putting in these hurdle pop-up questions, you had to go through, draft the questions, make sure that that they're answered in the videos, input them into the video. It was a time-consuming task that took a monumental amount of time. So to me, could we do it? Yeah, we did it, but I think it can be done better with more of the technology that's in the hands of private vendors. I'm always a little wary about the bars, the bar reviews. I don't want to pick on any company, but they're for a profit, and they're looking to make money. And frankly, they've been charging a lot to these students. They pay a lot for law school, and then they, charging, I think bar reviews could be up to what, $8,000, $9,000, $10,000 now for a course. And that doesn't even include New York law. So if we're going to put it on them, keep in mind the cost that it's going to go to these applicants. And there are injustices and equities as who could afford them, who cannot. And that's going to have an impact on bar passage.
Yeah, no, I appreciate that, and I think you did yo person duty in pulling it all together. But obviously, given the limitations and so forth, it was not and could not possibly be sort of the most sophisticated, technologically elegant and pedagogically, effective way of teaching. And, I don't know whether it's true or not. And I think like this is the beauty of these hearings, right? Because we get these ideas and then we can think about them more. But I recall that Professor Merritt, had a whole theory about how we could actually get people to do this and get a panel of experts in New York and so forth, and actually do it quite inexpensively and take that burden off of you. And so that's really why I was interested in your thought, and I'm so glad that you're open to it.
Yeah, I mean, we have not, as a board, discussed, a new type of course. We're certainly open to that. Again, I have to say cost. I've spoken with Debbie Merritt. We had some exchange of emails. I hate to see us get back into a position where we've got, the bar review companies hiring New York professors, and those costs are going to be turned around to the student. And I'm not so sure that's the best way. I mean, maybe with, a partnership, we've got the Bar Association there. We've got judges, if we can get the people to speak, give them credit for doing it, and then hire a vendor that puts it all together. Yeah, that's something I think, is certainly worth looking at. Because listen, we talked about, I think we get 17, 18 hours of videos. I think the largest part of that is New York Practice and Procedure. We know that by no means makes up for a New York Practice and Procedure course. Back when I graduated law school in '91, I took New York Practice and Procedure. It was 6 credits. Wasn't a required course at Albany Law School. I didn't take it because of the bar exam. I took it because I was already working part-time in a firm that practiced a lot in the New York courts. And, the partners I worked for told me, you need to take that because you're going to learn something on it. I don't know what happened over the years where the schools are not encouraging students to take that course. It's mind-boggling to me. When I speak to young lawyers, I say, you're going to be practicing in New York courts, you should be taking New York Practice and Procedure, not because on the bar exam, because it's going to help your clients.
Okay. Thank you, John. Thank you, Brian. This concludes our final public hearing. I want to thank the committee members and thank all those that presented and testified. And you're not out of the woods yet, John. I'm probably going to call you again and pick your brain. So I appreciate you taking my calls and you and Brian coming here today.
Well, anytime, Judge, and any of the other committee members, we're here. If there's any other information, data that you need, we'll be happy to provide it if we have it.
Okay, thank you. Everybody have a good evening.
Thank you very much. Bye-bye.
Bye-bye.